Any mention?
Please, Your Lordship. I'm seeking Lordship's indulgence, my Lord, in for listing of a miscellaneous application. Well, this is in the pending civil revision petition, my Lord, which is to be taken up by courtroom number 4. Now, my Lord, the order under challenged, which, my Lord, is pending before the court, my Lord, a similar order has been passed by the trial court. And it has given us time till the 14th, which is tomorrow, to remove all our goods. There is some urgency in the matter, my Lord.
Mentioned for the court.
Well, court is not there, my Lord, today. Court is on leave.
Which one? Court number 4?
Court number 4.
Court number 3.
I'm sorry, court number 3, my Lord.
And you mentioned for Chief Justice then. Oh, he's not sitting singly.
Well, he's not sitting singly, sitting
very, curious situation.
Can we take it today?
How can we take up the matter?
It can be taken up tomorrow, my lord. If your lordship takes up the matter, it can be taken up tomorrow because Mr. Sen is.
Court number 3.
But tomorrow also it's okay because I have time till tomorrow, my Lord.
Yeah, let it come just tomorrow for that court.
Much okay.
Although it's very irregular.
Well, because well, there's no single wedge, it becomes difficult for.
But then you mentioned tomorrow. He'll be there tomorrow in the morning.
Well, again, my Lord, because I have time only till tomorrow, my Lord. Well, there is a notification, my Lord, where
you
my Lord
file it and then you mention
any,
tomorrow. I don't think it's proper that I grant permission from my court.
Well, but there is a notification where, my Lord, any urgent matters can be taken up by this honorable court.
This court can take it up if it's a fresh matter, or if it's a pending matter. You file a miss case, you want to move it today.
My Lord, I've already filed it in the morning, my Lord. There is some urgency, my Lord.
They'll come tomorrow then. You give tomorrow is before that court.
Much obliged.
Yes.
Any mention?
May I please, Your Lordship, I beg to mention item number 64. My senior is on sanction leave, so the meeting will come after 2 weeks, my Lordship.
There's no such thing as sanction leave. Is he on leave or not? Because advocates are free agents. They don't need sanction from anybody. Yes. 64. Yes, Mr. Day.
I have nothing to say.
2 weeks, yes.
It's obliged.
Lordship, I beg to mention item number 78 of the main list, Lordship. Lordship, I'm praying if this matter can be taken up after a week, Lordship.
Why? Huh?
Need some time, Lordship, to prepare this matter.
You all just want to do motion, that's all. Sad to say,
We'll
Mr.
take it up,
Chanda,
Lordship.
sad to say, Chanda, you all just want to do motions and urgent matters, hearings, we just adjourn them, carte blanche.
Lordship, we'll take it up, Lordship, positively, Lordship.
Totally time bound claim.
Yes.
Totally time bound
It
claim.
is not, Lordship, it is not, Lordship. They are saying that it is time bound.
Argue it's not
Yes,
time
yes.
bound.
Lorena Lindo,
NK Trading, Lordship.
78.
78.
Lordship, 78.
For appointment of arbitrator is totally time
It
bound
is not,
claim.
Lordship. In fact, in the year 2025,
Okay, 2 weeks,
Lordship,
yes.
they have paid us the amount which we have received on dispute.
Yes.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 76, Lordship, on behalf of Mr. S. Thapa.
Why?
Lordship, he's currently having some personal difficulties, Lordship.
We have no objection.
Yes, 2 weeks. Yes.
Obliged, Lordship. May it please, Your Lordship. Your Lordship, I beg to mention item 67 of the hearing list.
So, all Mr. Paul's matter. Mr. Paul is going to do hearings. Who's appearing for the
My Lord, I'm
petitioner?
appearing for petitioner.
Your objection?
No, my Lord.
Yes. 2 weeks. Yes.
Highly obliged. Your Lordship, I have similar prayer for items 70 to 74, Your Lordship.
Where's Mr. Paul?
Your Lordship, he's having some difficulty.
Only urgent matters you all want to do. Very sad to make observation, but it's only fresh matters, other matters where order necessary. With hearing matters, you just dump it in the wherever.
Your Lordship, in these connected matters, there's a similar order which was passed by this Honorable Court, Your Lordship. We need to examine, Your Lordship.
Come after 2 weeks, then, Your Lordship. In my humble and respectful submission, that will not be applicable in the present case.
What's the matter about?
Your Lordship, this matter is where the petitioners
regularization, Your Lordship.
regularize They were confirmed first, Your Lordship, and then later they were regularized. So
What remains in these cases then?
Your Lordship, the main issue here is regarding, Your Lordship, their benefits, Your Lordship.
Service benefits.
Your Lordship.
You have the brief, we can take it up. What is there?
Your Lordship, the only thing is that we need to examine the
After 2 weeks, then your lordship.
2 weeks, yes, 72?
74. Your Lordship.
74.
Yes.
Apply your lordship.
Item number 1.
Please, your lordship. Lordship, may kindly take up this matter on Wednesday or Thursday, subject to your lordship's convenience.
Any interim order you're asking for?
No, no interim.
No interim prayer?
Then that notice be issued.
You sure?
That notice be issued.
Where's Mr. Sen?
He has some personal difficulty, my lord.
This is again NOCMA matter, my lord. So notice has to go.
That's the state 26/9/24. Will issue notice.
My lord.
Mr. M.U. Ahmed issue notice.
Show me the list.
Mr. S.D. with Ms. S.D. Learned counsel is present except for the behalf of for 123 notice to go to remain response within 2 days, just after 2 weeks.
Item number 2.
Commissioner, my lords.
Yeah.
Am I audible to my lords?
Yes, it's very audible. Yes.
My lords, by the present petition, my lords, I challenge the action of the respondents in as much as my APAR has been spoiled, my lords. I have been given a below benchmark grading. Your lordships may kindly have page 59 of my petition for a minute, my lords. Page 59 of my petition, my lords.
Yes.
My lords, this is the comparative table of the grading which has been given to me by my reporting officer who had supervision over my work. And my lords, the next is the table showing the reviewing authorities benchmark, my lords, grading.
7, 6, 8, 6, 8, 6,
Yes, my lords.
7, 6, 3.0.
Yes, my lords.
Yes.
Very well. Now, my lords would kindly have, my lords, page number 61.
You were represented against this. What happened after that?
My representation went on 9th of November 23. I'm so glad your lordships asked that question. My representation went on 9th of November 2023. As per the OM alerts, that representation has to be decided within 30 days. Mine was decided after 18.5 months. 1.5 years. Once the OM mandates the representation to be decided within 30 days, my representation, your lordships, is at page 247. Below benchmark grading given, remarks which have been given, your lordships may kindly have for a minute, page number 62.
Yes.
For a minute, your lordships has page 62. The remarks is the officer, despite his qualification, couldn't perform in the interest of the organization. He couldn't function well in the team and his efforts got diverted against organizational goals. The non-submission of APAR in time itself is testimony of such attitude. His loyalty to organization is shaky. Your lordships may kindly mark this. And below it continues. And he's in the habit of criticizing his superior officers and disobeys his or their orders. He's an habitual offender. Your lordships may kindly have, my lords, the OM which is dated 23rd of July 2029, my lords, which at page number 319. 319.
Yes.
Starts from 318, relevant is 319, categorically says, wherever accepting officer has been prescribed in the existing system in the cadre, columns may be provided for such authority to give his comments on the remarks of the reporting and reviewing authority and details of difference of opinion, if any, with reasons for the same. And if your lordships would now come to page 62, there has been absolutely no reason recorded for giving such comments without any inquiry. I've been termed to be a habitual offender. Lordships, the most important thing your lordships needs to see it as page 13 of my petition. Page 13 of my petition.
What is this partially over-assessed by the
yes.
inquiry officer,
Yes,
initiating
exactly
officer?
what I'm saying. But he gives a comment that there is a over-assessment by the initiating officer without recording any reasons, and that is why.
Because the initiating officer says so and so the qualified officer has worked.
The initiating officer is at page 61.
Yeah. He's
forward. Page 61. But page 61, he says, Sri Rakesh Chopra is a qualified officer and has worked as a staff officer to CE Project Sevak. The officer is aware of the rules and policy on the subject of roads and bridges. He's straightforward. But the grading given to me is 7. Has your lordship's got that? 7?
Yes.
May I show something very conspicuous to my lords? My lords, may kindly have page number 59, my lords.
So you're alleging that there's a malicious persecution against the.
What I'm saying is that there are 3 OMs in my favor. The first says every comment by the reviewing officer has to be given by 31st of August. Has to be given by 31st August. In my case, your lordship sees page 62. It has been given on 26th of September.
Then we'll issue notice. Yes.
I have a request, my lords. Again, this is something which is coming into my promotional aspect. Your lordships would consider keeping this matter also on 24 August for their counter affidavit, for their reply.
I'll require some more time.
24 August? Next year?
24th of October, my lords. 24th of October, my lords.
As heard Mr. N.K. Gupta, that comes a petition issue notice, Dr. N. Mozika with so and so. Is all the respondents?
Well, 5 and 6 are named in person, my lord.
Oh, yes, sir. Accept notice on behalf of the
But that takes steps.
Number 1, 2, and 3. Steps to be taken. 1, 2, 3, and 7.
4 also. 1, 2, 3, 4,
and 7. Steps to be taken as the respondents 5 and 6 have been named in person. Petitioner to effect service within. To take steps within 3 days for issuance of notice. Stop this after 2 weeks here. Just on 24th.
Before the affidavit not possible. The paralyzed instruction have to come from Delhi, my lord.
24th is when?
Today is the 30th. It's only 10 days.
That we'll see. No
3 weeks time, my lord.
Yeah, 3 weeks time. You really can't obtain. There's no point. It'll be a futile exercise to list it on 24th. Yes, next.
Item number 3.
We'll examine the matter.
As your lordships would please. As your lordships would please, my lords. No difficulty. Because I convey my possible date to my associate. Yes. I'm so obliged.
May please, Lordship. Lordship, this here petitioner, they are the contractors, Your Lordship, because they have participated in the tender process. The tender process, there is a terms and condition in the tender.
Who are petitioner?
Yes, this petitioner actually petitioner number 1 is the Architect Contractor Union and others.
So where the list of the members?
List of the members is Lordship. He is the
2, 3, 4, 5, and 6 up to 8.
Yes, so 1, 2 to 8, they are the affected persons, and this
what is your
number? The grievances, Your Lordship, there is a terms and condition where in the tender short tender notice they have given, they have that like to submit the PAN card and submitting the tender, the registration form and GT certificate, GST certificate, and many other. They have given those terms and conditions. While submitting the terms, this tendering, they have to fulfill this terms and condition which is provided in the tender form. Now the petitioner, the grievance of the petitioner has submitted all the requirement, asked for the terms and condition given in the short tender notice. We have submitted all the documents, but despite of submitting, our tenders are rejected. Whereas the private respondent number 2 to 32, they have not fulfilled all these terms. Some of them they have submitted without
the general kind of petition. What is this?
No, not general.
With what?
Not general.
That you have all the requisite documents.
Yes,
and
yes.
Your tenders been rejected.
Yes, rejected.
Why? Where is that? Let's see.
We have yes. In my pleading, I have categorically mentioned, my lord. It is a
let's see from some physical.
That lordship, they can let them. So
let them. Why let them?
Lordship,
they help you build your case for you. Why should
no, not
oh, show me where you say that there's been some violation. Where the terms of tender. Where? This
terms, page
this
20
NIT, this
page,
is dated 19
yes, page 23. Page 23 is the terms and condition.
Okay.
Page 23. And I have mentioned also all the what the private respondent what they have not submitted. Also, I have mentioned categorically.
So this short tender notice is for construction of walls and so forth, right?
Yes.
Okay. And then let's see term conditions.
This is the terms and condition. The terms and condition is page 23. Is the tenderer should bear the signature of the contractor, otherwise the tender will be rejected. All these terms and condition from 1 to
Now, where
10.
do you say that these people have not, whoever ordered contract have not fulfilled these conditions?
Because we
Where's that?
Lordship, we filed the RTI. Once we filed the RTI, then we were given the volumes of this one, and it was so much volume of paper. But in the record, we have found out that these people have not submitted those.
Where's that? Where have you written that?
Yes,
Where's that in the picture?
para 9 I
I
have
want to see the para from here.
categorically mentioned, my lord. Para 9 I have make a mention very
We
clearly.
can't just go like shooting in the dark.
Not shooting the dark, my lord. It is on record, your lordship, because if we go by the record, it will find
What
because they
record?
have not submitted. I
You
have
submitted the record.
I have mentioned very clearly, lordship. This actually this para the who are the which respondent have not submitted, what they have not submitted. Everything I have mentioned very categorically, specifically.
Where's that? Now you say
Para 9.
stated as per a private respondent is not concerned. She has not registered a contractor. Where's that from the RTI that she's not a contractor?
Yes, that it is on their record, my lord.
Then where is it?
That record we did not enclose it because
Then you see point number 5 has put less court fees. Where's that? Then number 6 has not included PAN card.
yes, we have.
Then
we have mentioned.
number 11 court fees. Number 12 has not signed the document. 13 invalid contract registration. 14, 15 insufficient court fees. 16 invalid contract registration. 17 invalid contract.
Yes.
18 where's that?
We were only given only to show because they were that document entire document they don't punish us to us.
Please understand, Mantaji. You have come before the court
Yes.
seeking some relief
Yes, Lord.
for the petitioners who feel that they've been unjustly rejected from the process, correct?
Yes.
Now, your grievance is founded on the fact that the people who have been awarding these contracts do not satisfy the eligibility conditions given in the terms and conditions, in as much as for the reasons that you mentioned is para 9.
Yes.
Right?
Yes, Lord.
Now, show those papers.
Because those
You expect this court to brief word of mouth.
Lordship, no.
Then,
because we are not able to increase
because what? You said we have got the RTI, we've got voluminous papers. What can this court do?
No, Your Lordship. On those only those particular, they were only give us as per the instruction of the petitioner. They were
Where
given
is
only
that?
so.
Where is that?
It is
Can you
on
just make
only
it a
on
false statement?
office record. They don't
Now,
punish
as
us.
said
Only
today,
the
asking Mr. P.D. Sangma practicing in court without valid bar council registration. Then you say no. I said no. I put it in my petition.
Lordship,
But then I have to show that you're not registered a bar council.
Lordship, you are right, Your Lordship. What I'm saying is because they were only.
I'm right. I'm left. It's not a matter of. But the thing is that the only thing is you common materials. How will it enter the petition?
Lordship, then I will bring on record. Just give me. I will file an additional affidavit. Just
File fresh.
only
He
those.
spent some money in court fees. See, you could spend money in court fees. No, not much. Yes.
I will bring on record. I will just file those
tomorrow. Take instructions. Mr. P.T. Sangma on the queries of the court. Please allow to obtain instructions this tomorrow.
Lordship. Yes, Lordship.
Item number 4.
Much obliged, Lordship.
May I be Lordship?
Yes, Mr. Kumar.
My Lord, the petitioner is retired from service, my Lord, in the year 2018, my Lord. During the service period, my Lord, he has lost his hearing power, my Lord, due to the firing practice, my Lord. And after the retirement, my Lord, he has claimed for the disability lump sum compensation because his medical category has been recorded as H3 T24, H3 permanent, my Lord. That prayer has been rejected, my Lord, by saying that this disease is not attributable and aggravated to the service, my lord. So today I am praying for
Yes.
only notice, my lord.
Heard Mr. V. Kumar, learned counsel for the petition issue notice. Dr. N. Mozika is present, except notice will be with so and so. On all respondents?
Yes, ma'am.
No further notice called for. If after 3 weeks for instruction, the affidavit. Yes.
My lord, item number 5, 7, 8, 9, 10 and 11 are similar, my lord.
All disability?
Yes, ma'am.
Yes, my lord. Disability terms.
4 to 11 except 6, my lord. Except 6.
Except 6. Except 6, my lord.
4 to
11 except 6, my lord.
4 to 11 except 6. Okay. Yeah.
Separate.
Item number 6.
The new rulings on disability, the Supreme Court.
Yes.
My lord, item number 6, my lord.
Yes.
Presently, he is serving as a Havaldar nursing assistant in the Assam Rifle, my lord.
Yes.
And the allegation made against him that he has replaced some document from his service record, my lord. On that allegation, my lord, court of inquiry was conducted, but court of inquiry opinion and finding has not been served to the petitioner, my lord. He has submitted the representation on this regard, my lord. And the respondent authority says that the court of inquiry copy may not be served to the petitioner.
Why?
So, in this matter,
Yes, Dr. Mozika.
it's simple.
I'll file affidavit, my lord.
Yes, heard Mr. V. Kumar issue notice. Dr. Mozika accepts notice with Kunso. Is present on behalf of all the further respondents called for. List up to 3 weeks for instruction the affidavit. Yes. Yes.
Much as lordship.
Item number 12. Item number 12.
Yes, what is this?
But here, my lord, this is basically for regularization, my lord. But here, what happened, my lord, the petitioners were selected for undergoing course, my lord, and on the condition that they'll sign a bond for serving the state government. So after completing the course in 2010, 2011, my lord, they came back and joined the department. For the last 14, 15 years, they are serving regularly, my lord. Now, my lord, what has happened? The state has come out with office memorandum, my lord. Lordship will see that page 44. My lord, the purport of this office memorandum, this is dated 25th September 25. It says, my lord, though, page 44.
Yes.
So
Let's see, what does it say?
it says primarily, my lord, that ad hoc employees in the state, which are about 1,514 ad hoc employees they have counted, my lord, all of them will be subjected to MPSC examination, my lord, at this stage, by giving one-time age relaxation, my lord.
Where does it say?
But if I may just take a lordship to para,
SOP for recruitment number 4.
my lord, para 1.4, based on preliminary information compiled by the personnel AR department from input.
Where reading from? Sorry.
Para 1.4, my lord.
Okay, one yes.
But if I may read from first para itself, my lord. The cabinet in its meeting held on 26th August 25 considered the issue of a large number of sanctioned posts in government departments being occupied by ad hoc appointees appointed after the cut-off date of 31st December 2007 and approved the proposal to conduct fresh recruitment to these posts through competent recruitment agencies. Successive government instructions since 1978 have prohibited ad hoc appointments of outsiders who were not recruited by MPSC or DSC or other duly constituted recruitment boards committee. Despite these instructions, ad hoc appointments continued in several departments, leading to long-term occupation of sanctioned posts in contravention of recruitment rules and state resolution policy. The cabinet has earlier approved regulation only in respect of ad hoc employees appointed on or before 31st December 2007, subject to strict conditions. Appointees made after the cut-off date are not eligible for regularization. Based on preliminary information compiled by the personnel in ARB department from inputs received from various departments, about 1,514 ad hoc employees appointed after 31/12/2007 are presently occupying sanctioned posts. This figure is indicative only and subject to verification by the, you can skip the rest, my lord. Next para, to ensure that the incumbent ad hoc employees are not unfairly excluded from participation merely on grounds of age, a one-time relaxation of upper age limit will be operationalized through the issue of certificate of age condonation valid for 1 year. So,
yes.
So my lord, basically what the government is trying to seek, my lord, to subject them to MPSC examination after they've rendered service for 15, 16, 17 years. Now, my lord, the petitioner's case is that he was appointed on bond, my lord.
When?
2011, my lord.
11? Which department is this?
This is weaving and sericulture, my lord.
As what?
As a weaving demonstrator.
Where is the appointment?
Well, I'll just take a lordship to the appointment order. Page 28.
You mean to say you came to a selection process?
My lord.
That time when you were appointed?
Selection process in the sense, my lord, there was an advertisement for undergoing the diploma course. We applied for that. Government nominated our name for undergoing the course, my lord. That the lordship will kindly see at page 18.
Page?
18, my lord.
This is 2000.
May please, your lordship. Lordship, the appointment orders at page 28, lordship.
Well, that's, you know, they're saying they've come through a selection process.
Yes, my lord.
So they'll put them different footing. If the ad hoc, backdoor entry, backdoor exit.
Page 19, lordship will see.
But then whether they came to a selection process, no, whether they have any trappings of regular selection.
Yes, ma'am.
And whether it should be put to.
Yes, ma'am. I'll establish that, my lord.
Yes,
page 19, lordship sees, my lord. From Joint Director of Technical Education, Director so and so, admission of students from Meghalaya for undergoing study in diploma level course in engineering, pharmacy so and so. My name is Deepamala Porvin Kari Shalam, branch of study textile. Next page is the bond, my lord, we signed for undergoing the course.
Okay, then. What's the bond amount? No idea. Anyway, yes, continue.
Now, my lord, appointment was issued. Page 28, my lord. The petitioner has been making NPS contribution, my lord. Lordship will see at page.
Temporary relief, 58 days, yes. Then?
Page 29, he has regularly been making contribution to new pension scheme, my lord. NPS.
Then,
my lord, lordship will see he was sent for training, my lord. Page 33. Further training, in service training, my lord. So, my lord, in view of the above and because of long period of service, my lord.
Now that means he was ill also in 23. It was reimbursed the state government.
Yes, my lord.
The cost of treatment.
Treatment also, my lord.
Then?
Now, my lord, because of this SOP.
Now, yes. Now what's your grievance now?
Well, the grievance is that because the SOP has come and department is asking us to give us all the papers for condoning our age and subjecting us to 1 year condonation of age, subjecting us to MPSC examination.
That's it.
My lord, now, my lord, recently, because of the length of service they've rendered, my lord, 15, 16, 17 years, there are other petitioners also, my lord. Now, of late, my lord, since 2024, there is a series of Supreme Court decisions, my lord, starting from Dharam Singh and Sri Palace.
He's working a sanction post, yeah.
They are working sanction post, my lord.
Yes.
There are, in fact,
they are distinguished from Uma Devi.
My lord, there are 18 sanction posts, my lord, and there are 7 ad hoc employees.
Yes.
My lord. But only the one interim protection I'm seeking, my lord, from the lordship.
Let me sing instructions, lordship, with this matter, because the Lord Advocate General will be leading this matter, lordship. If matter can come up tomorrow.
Tomorrow will not serve it.
Tomorrow won't make the situation better. You have to get instructions. But instructions also, because that's the SOP. Because only what the school wants to know whether this SOP you're going to follow it. You know, it's just a memorandum, whether it's incumbent on all posts or whether you're making it, you know, there is other
lordship will be incumbent on all posts,
or whether people just temporarily appoint ad hoc, you know, just picked up, appointed, whether they'll be, these are people included, or whether these people have been sent by training by the government, occupying sanctioned posts, all the trappings of regular employment, whether they will come under the same consideration.
Lordship, as per my understanding, all these posts which are sanction posts are being held by these persons who are appointed on a temporary basis, lordship. These are being straight line right now through this memorandum, lordship. So so that to avoid all these complications of these 58 days or so forth, Lordship.
No, but
try to-
they've been continuing from 2011 without a break.
Yes, my lord.
That break notional also.
Otherwise, also that break has no meaning, my lord. It's artificial break of 1 day.
Yes.
My lord, in fact, I've compiled a compilation of 12 judgments, my lord, of this year.
What do judgments now?
4 Supreme Courts and 8 High Courts, my lord. They said after you allowed someone to serve for 15, 16, 17 years.
Anyway, take down heard Dr. Nbozika with also consult for the petitioner. You should notice Mr. H. Karvanlang, learned additional senior government advocate, accepts notice on behalf of all the respondents. No surrenders called for. Stop the grievance of the split petitioner is with the impugned office memorandum, whereby directions have been issued for advertisement of vacant posts by way of open recruitment examination. Next, by Dr. Nbozika, Senior Counsel submitted that the petitioner has been working in the department, like the synopsis, is for more than a decade, no?
Yes, sir.
More than a decade, and was in various districts and has been working without a break in the concerned department. So it is submitted that the right of the petitioner for consideration for regularization has been affected by the impugned
Office order.
Office memorandum, Lordship, dated
25/9/25.
25/9/2025. We therefore praise that some interim protection be allowed at this stage itself. Next, from Mr. H. Karvanlang, Learned Counsel, Learned Additional Senior Advocate has played the of instructions and has submitted that the memorandum has been brought out in order to streamline such appointments which were not through a regular selection process, and employees and appointees were allowed to continue for long periods of time after 2007, after the cut of 2007. He submits. Any other thing you said? Nothing else.
Lordship, and if there was any interim order, it would affect the other departments, Lordship, which are trying to.
He submits,
because
further submits that if any interim orders are passed, it will have a what effect, you see?
Lordship, with regards to the recruitment, Lordship, because right now this MOM, the SOP is supposed to be taken over within 1 year, Lordship. All the recruitment drive is supposed to happen 1 year, Lordship. So we'll have
that if any interim orders will affect the entire recruitment drive, which has been contemplated under the impugned memorandum. So having held in the council of the parties, having examined the materials on record, so it is not disputed that the petitioner has been in service since 2011 and has continued as such in a vacancy against a sanctioned post. It is also noted that you've come to the court before.
No, man.
Then what are these?
My lord, this is an order with regard to same department where some petitioners came earlier, my lord, and their service have been regularized.
Problem? That is not seen, is not disputed. In the country as such. Yes. In this view of the matter, let the matter be listed after for constitution interim orders. For constitution, but however, it's provided that till such date the service separation shall not be disturbed.
Then
can't work for now 14 years.
My lord, one more interim prayer, my lord, restraining them from issuing advertisement with regard to our post, my lord.
My lord, then if in that case, Lordship, may have it tomorrow, Lordship, the Advocate General would
Where's the Archival General now?
Lordship, he's on next before division bench, Lordship.
Oh, he's here in Shillong.
Yes, Lordship.
Maybe
But
after-
may have it tomorrow, Lordship, because Lord Advocate General would want to address this
Then why
matter,
didn't you
Lordship.
say that in the beginning?
My apologies.
That he'll make. I thought he's not. I thought he's in Delhi.
No, Lordship. My apologies, Lordship.
Only that much, my lord, not to issue advertisement as far as we are
Because,
concerned.
Lordship, this will affect the whole
No, we are seeking.
recruitment process in state, Lordship. Then matter may be
Okay, no,
taken
no,
up
that-
tomorrow with regards
See, the
to.
thing is that you have to understand one thing. They've been working 2011. They went against seats which were reserved, they came selection process. They allotted those seats. They signed a bond. They appointed against vacant posts. They've been serving for so long. All the trappings of regular service they've been given. You've given them you allowed them to subscribe to the provident fund. You allowed them to. You reimburse the medical reimbursement. Is that what comes with ad hoc employee? You have to examine the nature of engagement that the government, had with them. That is why. Yes, Farma? Yes. Shall be disturbed, and also that the respondent shall not issue its advertisements against the said vacant posts. We have to balance it, otherwise.
Because the Lordship,
in front of after working 14 years.
In fact, the law has changed,
Out the street. The law has changed, so out the street.
13.
Similar, my lord, only the appointment.
Yes.
He is serving for 20 years, my lord.
20 years? 20 years?
Since 2004, my lord.
then, my lord, if this matter can be taken up tomorrow, Lordship, both matters.
Same department, same department.
If the matter can be taken up tomorrow, Lordship, both matters. Because
Then score order is this matters tomorrow on the prayer of Mr. So. Whatever connected matters are there.
Lordship, there's item 12 and 13, Lordship.
On the prayer of Mr. H. Karwanda, due to the unavailability of the General Advocate General, this matters tomorrow promotion. But you still tell you the court, you inform the Advocate General.
I will. Much
You
obliged.
can't just disrupt. Anyway.
14.
I oblige, Lordship.
Yeah, so appearing for the bank.
Lordship, I'm appearing for the bank, my lord.
You defreeze the accounts immediately.
My lord, I've just received instructions to appear just now, my lord. I have
Defreeze
no instructions about what is going on right now.
Whatever it is,
Let it come up tomorrow, my lord. I'll speak with the bank officials.
MSNG Shilla entered the parents respondent number 1.
One, lordship.
So such service complete stuff. She submits that she has just been handed the brief. And she has noted and prays the matter tomorrow. So he has noted that the matter concerns the freezing of the account of the petitioner appearing in person to an advocate of this court, who, in spite of a representation for the bank that she did not consent to any deposit made by an unknown source, the account is frozen. Stop. Though MS Engineers entered the period expected that by tomorrow the account should be defrozen.
My lord, I'll seek instructions, my lord.
Lordship, in fact,
Yes, tomorrow.
I have the instruction, Your Lordship, from the cybercrime.
Yes, what happened?
Yes, Lordship, kindly have a look.
Mr. ND Shly, opinion for number 2, also will place instructions tomorrow.
Lordship, I have the instruction, Your Lordship.
What? Defrozen?
No, Your Lordship. Lordship,
My
kindly.
lord, I don't have the copy, my lord.
We'll share with you.
Please share with me now.
Lordship, kindly see second paragraph.
No, you can't just freeze now. The law has to change. There's a reason Delhi High Court judgment just 2 days
Lordship,
ago.
I have read judgment, Your Lordship. Lordship, kindly.
Like whatever authority has to freeze, then you have to look at the nature, just not automatic. Is it Delhi High Court judgment?
Lordship, yes. That is yesterday judgment, Your Lordship. Nilkan Pharma Logistic Private Limited. Lordship, para 22.
(23)
22, Your Lordship. That paragraph 22. That is a suggestion made by the Honorable High Court of Delhi, Your Lordship.
That's just a general observation. Yes.
My lord, here I am the victim, my lord. My account has been freezed, my lord. And my learned seniors, my lord, they are not understanding my difficulty here, my lord.
Don't worry, they will, whatever expenses you need till the account gets.
We are under instructions, my lord. This is not a personal, anything personal. Much obliged, lordship.
My lord, can you direct
We expect it will be frozen by tomorrow, yes.
Highly obliged, my lord.
15.
Yes.
Yes, my lord, I have submitted the rejoinder on 22/9/25.
Yes.
So pleading is
Yes.
complete.
Posted for hearing.
Yes.
Yes, party submitted appeal is complete.
The only thing is there's an appeal provided under the Customs Act, my lord. They've come by 100%.
That I have, there is alternative remedy I have explained earlier. No. Is there.
16.
The question of mentality.
Yeah, questionability, the appearance of the questionability will be left open. Yes.
Please, your lordship. My lord, I pray for 2 weeks' time as the conducting counsel is on sanction leave, lordship.
Who which conducting counsel?
El Krim.
You are the person appearing here. Your name shown here last order also.
Lordship, I have no instructions to argue.
You are especially to ask for time, not to argue.
My lord.
Yes.
Objection, lordship.
Mr. Tigno
is also.
You are appearing or your he is appearing?
On behalf of Mr. Dingdor.
On the prayer of the parties.
Lordship, I'm appearing for.
When do you want it? Admission hearing?
16 to 48, my lord.
16 to
48.
For these matters regarding that KHDC?
Service matters, lordship.
It's for admission hearing today?
My lord.
On the prayer of the council for the parties, this is matter
after 2
on
weeks.
after 2 weeks. For admission hearing. Interim order finish.
Interim order may continue, lordship.
Highly obliged.
Is a service matters of district council?
Lordship.
16 to
48, 50 and 50.
48. And then?
50 and 52.
I'm for 59, lordship.
You're for?
49.
Only one matter you're appearing. Why? You're only. You didn't go the entire group. 49 record me, I'm doing you. From me.
53.
Highly obliged.
Your lordship, I require 3 days time, lordship. It's almost done, just the signatures are required. 3 days time.
My rejoinder is ready, my lord, in connection with the locate's affidavit. I'm filing it in the course of the day, my lord.
This is matter after this Adhar council for the respondent number 3 to 10.
3 to 10.
Please allow
a week's time.
Further days, a week's time to file the affidavit. Stop for the week's time. Prayers allowed. Ms. SDEP submits that the rejoinder to the after respondent to be filed course of the day.
Well,
yes, for 2 weeks for further orders. Yes.
54.
Same prayer. Same prayer.
55.
Obliged.
My lord, we have received the affidavit filed. My lord, we are waiting to seek instructions.
When do you file affidavit, Dr. Mudhika?
We filed on 10th October. Friday.
Mr. N. Khera, the council just submits that he just received the affidavit. He responds allowed how much time?
My lord, 2 weeks.
2 weeks obtained necessary instruction. Just thereafter. Yeah.
But here what happened, the clause says that arbitration can only be invoked after either work is completed or contract has been terminated, my lord. Now there was a termination notice issued to them. They've gone to commercial court and obtained a stay against that, my lord.
No, but you brought in record other proceedings.
My lord, primarily, my lord, where I am arguing from is that at this juncture, my lord, well, excuse me, I'm having a little cold. My lord, at this juncture, the court will have to only see the existence of an arbitration clause.
Don't worry, we'll look into that.
My lord, and my lord, my going to the court was only to safeguard my bank guarantee.
Yes.
56.
My lord, they have to file the affidavit. We have filed a miss case here for preservation of the CCTV footage.
Lordship, we are filing in the course of the day, Your Lordship.
Ms. Insurer AG so submits that the affidavit find the course of the day.
Lordship.
Just after 1 week.
Lordship.
Rejoinder in the meanwhile.
Lordship.
My lord, I'm waiting for the affidavit to come on board. I'll file one reply only.
Yes, Ms. N. Kira appearing for the petitioner prays that he may without file rejoinder if necessary. At least after 2 weeks then.
Obliged.
57.
My lord.
My lord, on the last date, Nehu wanted to file an additional affidavit, my lord, have not yet.
Your Lordship will be filing it during the course of the day.
MS Ibla submits that the actual affidavit which is allowed by this court by order dated 23/9/2012 we find the course of the day. Just after
2 weeks, my lord, for hearing.
2 weeks, yes.
Obliged.
Obliged, Your Lordship.
58.
May it please, Lordship. Lordship, here I'm supposed to file my rejoinder, Lordship, to the affidavit filed by respondent 1 and 2. Lordship, however, I'm seeking a week's time, Lordship. This is the second time we're asking for time, Lordship.
You want to file rejoinder?
Yes, Lordship, to the affidavit filed by the Ministry Committee.
Allowed for the 2 weeks time final opportunity. The second time now?
This is the second time,
For
Lordship.
the 2 weeks time to file rejoinder. List thereafter. Any interim order? No.
There's no interim order.
59.
Obliged, Lordship. Highly obliged.
Balik kamu enggak? Huh?
Please, Your Lordship.
Yes.
Lordship, I pray for further 2 weeks' time to file my rejoinder, Your Lordship.
How long? How many times have you
This is
taken?
the second time, Your Lordship.
Before the 2 weeks time that's prayed allowed for rejoinder. Just out.
Obliged, Your Lordship.
Item 60.
Also, in this matter, I'm appearing for respondent number 678, Lordship, the bank.
But the relief hasn't granted them. The matter can be closed.
Yes, Mr. S. Pandey is under the parents on behalf of respondents 678 as such the notice is complete on respondent. Yes, what is it? Yes, now it can be it's resolved.
Your Lordship, I have not received any instructions, Your Lordship.
Dr. N. Muzika appearing for the respondents 1, 2 and 4, 1 to 4 has submitted that has produced an order. What is the letter dated 19th September 2025 showing that the relief as prayed has since been granted and that the revised pension arrears will be paid shortly. He submits that the order of this court dated 28 June 2024 has been fully complied with. The copy of the communication is taken on board, paid matter of the record. MS N. Karsamlang, counsel petitioner, however, has no instructions. She prays that the matter is after 1 week. The NC instructions. You give her a copy also. This accordingly.
Much about hearing 62.
Okay. Okay. Welcome to division bench. Bench come on.
Lordship, clarification of the UGC is yet to come.
Yes, Your Lordship.
We are still waiting for the clarification of UGC.
May it please, Your Lordship? Your Lordship, on behalf of UGC, we just want to state the fact that the writ petitioner, he has been seeking regularization for casual laborers casual labour scheme of 1993. And Your Lordship, in order to satisfy this court, I want to put 3 submissions for my point. First submission being, the grant of temporary status and regularization applies strictly to casual labourers engaged in Government of India offices and their subordinates or attached offices. NEHU, on the other hand, is an autonomous organisation under Department of Higher Education. And to satisfy this court, Lordship, I kindly ask you to please take my affidavit in opposition, Your Lordship.
1 second.
Yes, Your Lordship.
So they're seeking regularization under this Government of India scheme 1993.
Yes,
What's the
Your
role of UGC there?
Your Lordship, they have made UGC a party.
Of course, they made. What's the rule? Any role you have to play? No.
No, Your Lordship, to be
Then?
very honest with you. But Your Lordship, just to satisfy the courts and just to make it very clear, Your Lordship, here it has been stated clearly that NEHU is an autonomous body. And as my affidavit, Your Lordship, Your Lordship, if you can please come to page 8.
Your respondent number?
3. Page 8, Your Lordship. Your Lordship, if I may read.
Yes.
Your Lordship, this states office memorandum dated 31st August 2023. And this has been forwarded by the Ministry of Personnel, PG, Pensions, Departments of Personnel and Training. Your Lordship, I can come to point number 3. It states, it is again reiterated the casual labourers.
Page 8.
Your Lordship, in the copy that I have.
Page 7 in this affidavit.
Your Lordship, I'm just reading from the type copy since the other copies are not very clear, Your Lordship.
Yes.
Your Lordship, point 3 states, it is again reiterated that casual labourers grant of temporary status and regularization scheme, Government of India 1993,
Yes.
is applicable to casual labourers engaged in Government of India and its subordinate attached offices. Since NEHU is an autonomous organisation under the Department of Higher Education, the employees working under NEHU are not covered under the said scheme. Further on, Your Lordship, I head on to my second point, my second submission being the very fact of this OM and also in the scheme itself, which is under page 34 of the writ petition, Your Lordship. Annexure 6. Even here it has been clearly and very specifically mentioned in point 3 as per the scheme that the scheme is applicable to casual labourers in employment of the Ministries, Department of Government of India and their attached and subordinate offices on the date of issue on these orders. But it shall not be applicable to casual labourers in railway, departments of telecommunication and departments of posts who already have their own scheme. Your Lordship, even here it has been clearly mentioned that NEHU is not a part of it. And in my final submission, Your Lordship, I just have to mention that the administrative and service matters of NEHU falls solely under jurisdiction of the parent ministry and not of UGC. Moreover, UGC is not an appointing or administrative authority for
Yes,
the petitioner.
Mr. Sen. Yes. Anything else to say, Mr. Datta?
My lord,
Yes, what do you have to say?
NEHU
The scheme is not applicable.
is an autonomous
you're
body, my
seeking-
lord.
One thing, listen. Have the NEHU adopted the scheme?
Yes, it
You
is
have
an
to-
autonomous body and it has extended the benefit of the scheme at its own.
Okay.
And now it is passing the buck to the UGC. It is not the scheme of the UGC, my lord. It is the scheme of the Government of
clear.
India.
Yes.
And moreover, Group D post is not abolished, Your Lordship. It is upgraded and termed as MTS, multitasking staff. And we are entitled to for regularization as MTS after the upgradation and the benefit has to be extended in toto, Your Lordship. The scheme has to be extended in toto, not in piecemeal or according to the convenience and liking of the university.
Yes.
Now they are, sometimes they are passing the buck to the Government of India, sometime to the UGC. In fact, it is not the scheme of the UGC, it is the scheme of the Government of India, which the NEHU has adopted and extended to the casual laborers.
Where's the letter where they adopted the scheme?
Actually, they have given the temporary status under the
Where's
scheme.
the letter where they see the scheme has been
There is the order, Your Lordship.
Where is that?
At page 39. First, I'll read it. In pursuant to resolution number so and so adopted in the emergent meeting of the Executive Committee 67, meeting held on 21/2020, the Vice Chancellor is pleased to confer temporary status to the following casual laborers. Then I skip the names. With effect from 1st September 1993 in accordance with the GOC scheme, Government of India scheme, by Department of Personnel Training, OM so and so, adopted White Executive Council resolution number so. So they have adopted the scheme.
This is the scheme, this memorandum.
The scheme is
adopted by Executive Council resolution number so.
The scheme is at page 28, Your Lordship. The scheme of the Government of India.
Yes.
NEHU has adopted this scheme, my lord. The entire scheme.
Where's the resolution? Has the NEHU annexed the resolution whereby they have adopted the scheme?
Yes, my lord. Here I have just now.
Where is that? Not from that order, not page 39. The EC resolution.
EC resolution is not annexed here, Lordship. But it has been mentioned here.
No. Have they annexed it in the affidavit? Mr. Sen, is it your case? Yeah. Why?
Well, this is something else, Your Lordship. I'll clarify. This is nothing to do with my lord. That adaptation, my lord. This, my lord. What happened, Your Lordship? Admittedly, number of.
See. One thing. Just listen.
Yes.
Why? I was asking because I want to see whether that EC resolution, whereby the GOI scheme have been adopted and they've been offered temporary status under that scheme, and which was also like adopted by your Executive Council resolution. The court wants to see that. What is it?
I'll just
you produce it.
I'll do it. Small clarification, my lord. Now, admittedly, that 1993, my lord, scheme that is formulated by the central government.
It is here, my lordship.
Central government, my lord. It means for the my lord benefit of those employees, casual employees. What my learned friend has pointed out, absolutely correct. For the central government department, not for autonomous body. Number of cases lordship is doing recently one pension, unless it is extended by the UGC. 1998 UGC formally extended this scheme to the university. This is not here.
Here is the resolution.
They have only in 98, though it is of 93, only 98 UGC has extended this to the university, all the central university. So, my lord, we have to, my lord, follow it, and that's how we are following it. But that 98 somehow neither in the writ petition, my lord, or here. Number of cases, lordship, recently I think one pension.
How come that council for UGC said that has given contract submissions?
I don't know. That 98 letter, that will be clear. That is issued by the UGC.
That
Number of cases, lordship is given.
Incorrect submissions.
No, Your Lordship.
Then?
Your Lordship, moreover, we're stressing on the fact that UGC is not an appointing authority. It is not an administrative authority.
You're just a regulatory authority. You're not appointing authority.
No.
Remember that. The thing is that it has a overall supervision over all universities and universities. Correct?
Yes, Your Lordship.
Teachers' conditions and so on and so forth, and employees. Now the thing is that have you extended the scheme to NEHU or not? That's
No,
the
Your
question.
Lordship. Your Lordship,
But then just now, standing counsel for New said that it's been extended by UGC in 1998.
Yes, Your Lordship, I'm getting there. Your Lordship, the petitioner has asked specifically for the 1993 scheme. That's why, Your Lordship, we stress on that fact, Your Lordship.
You can't split hairs. The thing that there's a scheme in place, whether it's been extended or not. That's all.
Your Lordship, I'll get proper clarification.
What is proper clarification? Who's the person responsible? We'll make them appear personally if they're instructing you in this way. You're not only aware of what your left hand or right hand is doing.
Your Lordship, as per the affidavit that was given to them, Your Lordship, that was given to us by UGC itself, Your Lordship, they stress only on that part, Your Lordship. And even the OM that has been given to Nehu in 2023, Your Lordship.
Where's the 98? Let's see, Mr. Datta.
Here is the minutes of the 5th emergent meeting of the Executive Council of the Nehu. They have adopted the scheme.
Your Lordship, in the OM that was given to Nehu, Your Lordship, in my affidavit in opposition that I had mentioned earlier also.
Yes.
Yes, Your Lordship.
This is very clear. No, we don't want to hear anymore. Yes, where's Mr. Sen?
Yes, my lord. So, my lord, it was extended to a very formal communication of 98. Somehow, my lord.
Is here.
My lord?
The resolution is here, the resolution.
No, this is which resolution? My lord, I have not seen.
Yes, kindly see it. 13th August 2018. Don't understand why. Where was data? Group C, Group D post abolished? Where's that?
It is not abolished, Your Lordship. It is actually upgraded and termed as MTS.
Where's that?
My lord, this resolution is not, my lord, adoption of that government of India.
No, they've granted that thing.
They've granted it. This is enforced.
What is important is that they are seeking reliefs whatever they can get from the scheme.
Yes.
And as per Nehu, they were given the status as per the 93C scheme.
Yes.
That's all. So there's no
doubt about it.
Yes.
That was extended to university by the university.
Yes, so further from the scheme, whether they can derive anything, that's the only thing the court has.
Exactly, my lord. Now, in the meantime, my lord, our only problem, we want to do it. In the meantime, following 6 pay commission, my lord, the post has been upgraded and redesignated. My lord, group
that's exactly how do you tackle that?
Now, how to negotiate that, my lord? That requires a higher qualification, technical qualification. So, my lord, what we did, we wrote a formal letter to the ministry with a copy to the UGC. There is no response from the UGC. And it's not, I am not saying UGC is the appointing authority.
It is in the pay commission report.
So where's that?
6 pay commission. I can bring it on record, Your Lordship, at the moment.
I just want to just go and see it, that's all. What does it entail?
There it is mentioned that the Group D post has been upgraded.
Where's that?
I have not annexed here, Lordship. It is with the petition because...
This will be, my lord, at 2010, page 12 of my affidavit.
Page 10.
Page 12, my lord.
Oh, yes. See, there'll be no further recruitment Group D. They're already in Group D, right? No further recruitment.
No, they are not in Group D, my lord. They are not against any post, my lord. There should not be. They are enjoying temporary status, my lord, without holding any, my lord, regular post. Now, what the scheme contemplates, your lordship, going to, it say, if they temporary status, my lord, without any post, they complete 2 years after temporary status. Then, if there is a vacancy, clearly mentioned, if there is a vacancy in Group D.
No, what's the situation now?
Here it is clear.
They are without any post.
In the same memorandum, see number 2, one is there will be no further recruitment in Group D.
Yes.
Then again, 2, the existing Group D post will be placed in Group C, band with.
Okay, one thing, Mr. Datta, what qualification do you have? This petitioner.
Actually, according to this scheme, the scheme is silent about qualification.
No. He has written the minimum qualification for appointment this level will be either 10th pass or ITI equivalent.
Multi-skilling one employee performing jobs hitherto performed by different Group D employees. Actually, it is according to their skill, your lordship.
No.
Commensurate with their task.
No. See, minimum qualification and then multi-skilling one employee performing jobs performed by different Group D employees. See, in this regard, the other recommendations of the Commission,
minimum qualification.
The 6 CPC recommended so and so will stand agreed Group C, pay band so and so would accompany. These are the requirements.
Yes,
first,
minimum qualification.
There will be no further recruitment to Group D posts. Okay, because Group D has been abolished in a way. Now, the existing Group D posts will be placed in Group C under a different pay band.
Yes,
number
lordship.
2. Number 3, but the minimum qualification for appointment level will be 10th pass or ITI equivalent. So that is those are the thresholds you have to meet.
Actually, this is for.
You can't just pick out number 4 and say multi-skilling one employee performing jobs. You can't pick that out and say that, like because of one qualification I have out of 4 or 5, then I will be eligible for upon Group C post. Or where would it leave them? Nowhere.
This is the problem. That's why we have written. I am not saying UGC is the appointing authority. They will have to sort it out. They have extended it.
Forget your UGC. See how are you treating them? How are you paying them?
No. How it happened, my lord? I'll just tell you.
How are you paying them
98, now? My lord. 98. What happened, your lordships? This was extended. It's the 93 scheme, my lord. Then thereafter, who are eligible, my lord, immediately we granted. There are some people who are short of, my lord, 1-2 days short, the 240 days. Now, ultimately, at the intervention of the court, I mean, yes, my learned friend has annexed the order of the court. At the intervention of the court, my lord, court was a little flexible, my lord, 1-2 days here. So, my lord, taking into consideration court's order, my lord, these few people, my lord, around 10 people, we have granted them. But in the meantime, my lord, this happened. Now, what is the option for the university? We had to write, my lord, and we have written to the UGC till date, no response. So, my humble suggestion, only UGC can sort it out. It's not the question, they will make the appointment. They will have, there are, I think, altogether 12% like this.
See, you see how it is sorted out. It comes under the scheme.
Under the scheme, my lord.
If Government of India, it is had sorted out.
No, Government of India, my lord, so far, my lord, this personnel, they have category, what my learned friend said. Normally, my lord, this scheme has no application in the autonomous body. It is the UGC, my lord, by a 98 letter, formally extended.
Them nowhere then.
98, my lord. So, if the UGC...
How can you resolve this then?
This is the only way out, my lord, my humble submission, my lord. Being the regulatory authority, my lord, since UGC has extended this, now because of this development, they should answer it. We have written a letter, my lord, let them answer it. And then we'll
Where's the letter?
Letter I have annexed, my lord. In my affidavit. Page, my lord, 8. I have addressed it to the Ministry of Personnel, my lord. Actually, it should have been addressed to the UGC.
There's no reply to this.
This from personnel we have received a department. Same thing, what my learned friend has submitted for UGC. Exactly. This has no application to you. And we have sent a copy of this to the UGC. With reference to the subject.
Who will bell the cap?
Well, UGC. It has to be UGC. It only UGC can sort it out. Now we just cannot, neither we can create a post, nor we can relax. Nothing is in our hand.
But then the submission UGC is that they're washing their hands off.
No.
They think we never, they're autonomous
98.
body. No. They can't do that.
98 they have extended. I think this is wrong, my lord. I think my learned friend will seek clarification. The number of cases we have done on this temporary status, and normally that 98 communication are annexed.
Your lordship, you give me a week's time, your lordship, I'll give clear clarifications. But your lordship, I'm still sticking to the point, the fact that we are not their appointing authority. They don't work.
It has no relevance appointing authority. You're a regulatory authority. Remember that.
Yes,
Regulation and appointment are two different things.
But your lordship, even the administrative process is all carried out by NEHU.
The counsel for the UGC response number 3 today has submitted that the UEC not being appointing authority, they exercise no control on the service conditions of the petitioners who are appointed under the respondents. You are what number? 4 and 5.
4 and 5.
4 and 5 University. It's further submitted penal counsel that since 4 and 5 autonomous body, any decision taken will have to be at the level itself. So, in this case, next paragraph, it is noted that the claim of the writ petitioners is to reservation under the scheme is dated when? Under the where the
scheme of the government of India for
where that scheme?
28.
Under the
28.
Under the scheme. Is based on the scheme called, within inverted commas, casual laborers
grant of temporary status.
Please, open bracket, grant of temporary status
and regularization.
Please, Mr. Datta, you dictate the order. Grant of
Sorry,
and regularization.
I'm sorry.
Close bracket. Scheme of Government of India 1993. Stop. This scheme, it is noted, has been adopted by the responding university, and the grant of temporary status to the writ petitioners was in accordance with the same. However, as the circumstances has since changed, inasmuch as by an office memorandum dated 30/04/2010, whereby Group D posts for which writ petitioners would have been eligible has been recruitment thereto has been stopped. The claim of the writ petitioners therefore has to be examined in the light of the office memorandum, wherein certain other conditions such as minimum qualification have been prescribed. So, Mr. S. N. Learned Counsel for the University has submitted that the writ petitioners were yet to be accommodated in Group D posts, as there were no vacancies. And with the coming to effect of the OM dated 30/04/2010, the question of placing them in Group C necessitated a fresh consideration. Stop. It is submitted that the writ petitioners, most of them, lack the minimum qualification.
Yes, all of them, except one, what I have.
Yes, lack the minimum qualification. And as such, the responding university had sought clarification from the where is that?
That is at page 8, my lord, of my.
From the Ministry of Personnel, Government of India, with a copy to the UGC. Stop. He then submits that you receive a reply to this.
UGC has not replied, Ministry has replied. Ministry says this has no application.
Ministry, what does it say? Where's the reply?
Well, reply I have not annexed, my lord. Reply is this, your lordships. Reply is this, that what my learned friend said, these schemes is meant for central government, not for university.
It submits that the ministry in its reply has informed the respondents that the schemes are meant basically for the central government departments. However, he submits to address situations. It is only the UGC respondent, respondent number 3 UGC, which can issue necessary clarifications as it is a regulatory body. So, next paragraph. Having heard the counsel for the parties on this aspect and on the prayer of MS so and so for the respondent number 3 UGC, this is matter after 2 weeks to allow her to obtain specific instruction in this regard. A copy of the order be supplied to the Criminal Council.
Obliged.
51. 51.
Yes, Your Lordship. The respondent number 1 to 4 are yet to file their affidavit, Your Lordship.
He's come for hearing.
No, Lordship, this is for admission hearing.
Really?
Those connected matter in between this.
Where's the affidavit? Where's it?
We'll file after 2 weeks, Your Lordship.
Why after 2 weeks?
Your Lordship, we just have sent a parawise, Your Lordship.
You've received a parawise?
Yes, Your We just have sent, Your Lordship.
You just have sent the parawise?
Yes, Your Lordship. Reminder, Your Lordship. We have sent the reminder, Your Lordship.
What to do? What matter is it? Nokma?
Nokma matter, Your Lordship.
Read for 2 weeks, that's all. For a 2 weeks, that's a lot of affidavit, that's 1, 2, 4.
63.
Petitioner suffering from tremors, and I had showed to your lordship that the review medical board was not properly constituted. Now they had raised after the hearing, they had raised a submission that there are no vacancies. On that aspect, your lordship, I have placed on record certain judgments. Please, if your lordship would have my compilation. I have placed on record 3 judgments, 1 by Orissa High Court and 2 by Delhi High Court.
What compilation? Yeah, where's your local council? Where's the compilation?
The lordship have submitted before.
Oh, family.
Man, was just given just now. Yes.
But before going into that, well, first they have to make out their case whether prima facie they are able to. The question of vacancy or no vacancy will come later.
Please, lordship, I had submitted that, but I can again submit that. Please, the lordship would remember that this is a case of tremor. They had disqualified me on the ground of tremors on 15th of July 2023. Nearly 15 days later, I had got myself examined from AIMS, which had found no such tremor in me. The lordship would find that document.
Yes.
Please, the lordship would first find their review medical board result at Annex to P.
One second. Now, you see, they produced a communication last date. Oh, where's she gone?
Yes, Your Lordship, they had produced a communication.
15 July. Yes. No, we take it from there. Now, what is your case? Dr. Mozika?
Please, Your Lordship.
If he's found fit now, as per your review medical board, correct?
He's not found fit, man.
Huh?
He's not been found fit.
What about your 15 July communication?
Please, Your Lordship, they are yet to medically examine him.
Now, this was only, this 15 July is only with regard to what happened to the vacancy, whether it's been filled up or is still vacant.
Yes.
Then what happened?
Please, Your Lordship, then Your Lordship had to hear me on the aspects of vacancies. That's why I had placed on record the judgments.
Right.
Please, Your Lordship, my first submission is that this was a vacancy which was meant for state of Chhattisgarh. Now, in the next recruitment cycle, there was no vacancy published for the state of Chhattisgarh. So they could not have carried forward a vacancy which was meant for state of Chhattisgarh to any other states. That's my first submission. But irrespective of that, if Your Lordship would just have the judgments.
Yes.
Please, Your Lordship would have the first judgment of Odisha High Court in somewhat identical circumstances, where also the petitioner was disqualified on the grounds of medical disability. Your Lordship would have paragraph 21 of this judgment. This is where they discuss the aspect of vacancies. Para 21, 22
Yes.
and page 10. In view of the foregoing discussion, this court is of the considered opinion that the rejection of petitioner on medical grounds was arbitrary and unsustainable in law. The failure to constitute a medical board with a qualified urologist and the absence of a proper re-evaluation after corrective surgery vitiates the review process. Accordingly, the impugned rejection is quashed. Since the recruitment cycle has since concluded and the notified vacancies have been filled, the opposite parties are directed to consider the petitioner for appointment against a post of equivalent nature and status within the same cadre and pay scale as originally applied for, subject to his being declared medically fit by a duly constituted medical board. Such board shall mandatorily include a qualified urologist and shall complete the re-evaluation within 4 weeks from the date of presentation of the order. It is further made clear that the petitioner shall not be met with unnecessary vindictiveness.
You constitute a review medical board then, Dr. Mozika. Dr. Mozika, you constitute a review medical board.
The review is already been carried out, Lord. So kindly seize my affidavit, madam, the main affidavit.
Yes.
Please, it is this review medical board which I have challenged.
Page 18, madam.
So there is
Or the
no
first affidavit.
medical board.
You filed 2 affidavits.
This is affidavit of November 24, madam. Well, 2 affidavits.
Okay. Page?
Page 18, madam.
Yes.
Small review material at serial number 3, Lord. So see final opinion unfit on account of essential tremor.
Yes.
15 July 23.
Then what happened?
Nothing. And this is
Madam,
the
the-
medical board which I had challenged. This is the
Then he got examined in AIMS. Where's the AIMS and when writ petition is the
Your Lordship would find aims at page 32 it's starting
of your writ petition?
of my writ petition.
Yes.
Please, Your Lordship, you see 32 is the date 1st August 2023 and Your Lordship would first find the relevant at page 37. Please, Your Lordship, you see somewhere in the middle after the examination there's written no tremors and Your Lordship would find the final opinion at
Medical, this at page 38A.
yes.
Yes.
Patient is medically fit for recruitment to armies. And this is just 14 days later than their medical examination. And Your Lordship, I'll also point out one more thing that under the guidelines, if Your Lordship will see, I had also pointed out those guidelines. Page 58 is their guideline.
Yes.
Please, Your Lordship will see, I'm sorry, page 57 is where it starts. Following examples are cited for the guidance of review medical board. And if Your Lordship would now have seriatim G, any tremor in hands or other parts of body, thyrosities should be ruled out and neurologist opinion should be taken. Now, this was a case where at the stage of review medical examination, no neurologist was involved.
Yes.
In fact,
We'll pass orders, Dr. Mojika. Yes.
But only one thing, my lord.
Yes.
But the neurologist's opinion was taken, my lord, from Jayan Hospital, Dimapur, Nagaland, my lord. I'll just point that out, my lord. It is not necessary that a neurologist should be on the medical board, my lord. It only says, the guidelines only says that his opinion should be taken.
Where's the opinion?
Just place that.
Where's the opinion?
Please, Your Lordship, in fact, on the contrary, it was opinion of a radio diagnosis. There is no neurologist even in the Dimapur. Your Lordship would have, they have placed those documents with the second affidavit.
Yes.
Your Lordship would find those starting from.
Yeah, we've seen that. But then even the NC, Dr. Mojika, at page 13 of the additional affidavit,
my lord,
no significant abnormality detected. It's regarding cardiothoracic, so and so.
Yes.
So there's nothing to do with your tremors. We'll pass orders then.
One is a general examination and page 13.
If it's fit, you appoint him, yes. Yes. We'll pass orders.
Very well.
Yes.
65.
We had filed an application, my lord, for.
Wait, please, Your Lordship. In the meantime, there's a development. We have filed a transfer petition before the Supreme Court, Your Lordship, for transferring these matters.
Who filed?
The state has filed, Your Lordship.
Are you aware of this now?
No, my lord.
I am also aware only this morning. It was filed on Friday, Your Lordship. And so
Why?
that because there are similar matters of the different high courts, Your Lordship, before the Supreme Court. So you would like the instructions of that, this should also be placed there so that it can be taken up together, Your Lordship. Pertaining to different high courts, Your Lordship. Similar matters. This is our clarify.
You have two matters.
There are two matters.
Two matters.
So it is expected to be listed after 2 weeks, Your Lordship. So
Learned EAG submitted that in the meanwhile, in these matters, an application has been filed for transfer of the same to the Supreme Court as similar matters are pending consideration
of different high courts, Your Lordship.
from various high courts. According list after 3 weeks.
My lord, in the meantime, my lord, there's my application for modification of your lordship's order. That may be taken up, my lord. This matter has only been filed. There are no effective orders. We are seeking for modification of your lordships. Kindly
It
have.
will not serve any purpose, Your
Won't serve
Lordship.
any
The
purpose,
matter
but
is
it's taken up
transferred
there,
there, Your
then
Lordship.
They'll pass a general order with regard to service conditions.
It will not
And-
serve
and
any
that-
purpose, Your Lordship. If any
Maybe after
order
3
is
weeks, let's
passed.
see. If nothing is forthcoming, then we'll consider the thing. Yes.
Oblige, Your Lordship.
Deeply.
68.
Meet, please, Lordship. Lordship, here is a point, Lordship, where detailed medical examination was done and then review medical examination was done. And thereafter, Lordship, I was found on one count that I was unfit, Lordship. In fact, subsequently, Lordship, I had gone and done tests, Lordship, which says otherwise that, Lordship, I am fit, Lordship. And in fact, on the last occasion, medical expert was called, Lordship, and opinion was taken. Lordship, what I am praying is that since there is a conflict, Lordship, with regards to the
What did the medical experts say last time? Oh yes,
Page 62, my lord, Your Lordship, says, my lord, of the writ petition.
5-9.
Lordship.
Page 62.
Says, Lordship, because thereafter, Lordship, I had gone and done my testing at Nigrim's, Lordship. It says that no clinical radiological features suggestive of scoliosis.
No, but see the last order,
Lordship.
5-9.
My lord, the doctor pointed out, my lord, at page 62, Lordship, kindly sees, my lord. The certificate from Nigrim's.
No, see that order date 5
Yes, ma'am. Yes, ma'am. Even this report says 20 degree. Acceptable limit is only 10 degrees, my lord.
Well, it was X-ray whole spine TT 20 degree, which was done, Lordship. So, Lordship, since there is a conflict of opinion, Lordship.
There is no conflict of opinion.
And also, Lordship.
There's no conflict. Even the Negrim C.
Lordship.
C59 order. Just read, Mr. Chanda. Read final order.
Lordship.
You were here last time, correct?
Lordship,
no, you're not here last time.
I was not here, Lordship.
Yeah, you read the order. See, the medical expert came. Then
what if I may draw your Lordship's
middle experts here, Mr. Chanda. That's why we call a middle expert here to render her opinion. That's all. So she had examined the review medical board and also the report obtained from the agreements. Where's MS Ardata?
Lordship, she's not here today, Lordship.
Then?
Lordship.
She's the one who's arguing it.
Lordship, I was actually there, Lordship. On that day, Lordship, I was
what
not there.
What do you propose to do?
Lordship, only one
Nothing
aspect,
remains,
Lordship.
Mr. Chanda, in the face of expert opinion, what's this code? We can sit on top of experts.
Lordship, because
you take instructions from your client.
Review medical examination was done.
That is over.
Lordship.
You write on the Negrim's report, that's over also.
Lordship.
Then you take instructions.
Then Lordship may pass necessary orders, Lordship.
No, you take instructions. You don't dismiss it outright.
Lordship.
Yes, in view of the order date 5/9/2025, Mr. Chanda praised that immediate out of the instruction.
Next week.
Next week.
We can't carry on this.
Lordship.
69. 69.
Don't know. Yes.
May please, Your Lordship. Your Lordship, the conducting counsel, Mr. S. Sen, he's having some personal difficulties, Your Lordship.
And why didn't you inform the counsel?
Your Lordship, I was just informed, Your Lordship.
What's the matter about?
This is a compassionate appointment, Your Lordship.
When then? The application was made before 2012.
The first application was made in 2008. We decided the application in 2012. The last order was in 2023.
Lapse.
Yes, Your Lordship, but after examining the financial status of the family, Your Lordship, that is why she was not granted, Your Lordship. The mother was a...
When? After 1 week?
Lordship, second week of November, Your Lordship. After this, because I'll be taking leave, Your Lordship.
Why?
31st is my wedding, Your Lordship.
Oh,
preparing.
Of course. Yes, second
week of November, Your Lordship.
Yes, on the prayer of MS Ailingwa seeks some accommodation in view of the absence of the conducting counsel, the other respondents. This matter in the second week of November.
Much obliged, Lordship.
75.
Yes.
Lordship, this matter pertains to the petitioner's right to be considered for promotion. However, Your Lordship, the main counsel has encountered some difficulty throughout the course of the day. For that reason, I am humbly praying for 1 week.
Which the counsel encountered difficulty?
Kishore C.H. Gautam.
You're there, no matter?
Miss N.G. Shala is there. She's on her legs, Your Lordship. We're ready with the matter, Your Lordship.
He's a driver?
No, Your Lordship.
Your Lordship, he's a helper come... handyman come helper, Your
Where?
Lordship.
In which department?
In Kolkata, Meghalaya Guest House, Your Lordship.
Office of the Trade Advisor and Director of Movements, Government of
Due to
Meghalaya.
the absence of arguing counsel, petitioner, just after 2 weeks.
77.
Much obliged, Lordship.
Yes. Start.
May I please Your Lordship, this is a writ petition against the order dated 7/8/2024 passed by the CEM, GHEDC and GHEDC, Miss case number 41 AC of 2023 in GHEDC Review Appeal number 42 of 2023 containing the delay to file appeal against the order dated 13/4/1983.
You do not have to read from it, you submit naturally.
Yes.
Yes.
Your Lordship, brief of the case, Lordship, is that the Dokigre Aking belonged to the Bolwari Gimse Marak clan. Your Lordship, if we come to page 15, Lordship, of the writ petition.
Mr. Dib, ready? Or Mr. T? Ready of the matter? Ready? Very good. Yes, page 15, 1-5.
Yes, Your Lordship. Your Lordship, this is the order of the EM, Your Lordship. May I read, Your Lordship, the order?
Page 15.
Yes, Your Lordship, of the writ petition.
Yes.
Musadar reports seen Sri Nanjan Sangma and Batmi Marak applicants and 9 clan people, namely Dinjan Marak, Janan Marak, Onjan Marak, Assam Sangma and others appeared before me in my court chamber today with a prayer for the appointment of Nanjan Sangma and his wife Batmi Marak as the Nokma of Dokigre Aking Amite 4/50/12. Date Ganan Sangma and his wife Rikse Marak Michik were the foremost Nokma of the said Aking. Both of them died some years back in 1981, leaving behind their daughter Nokna Shrimati Patmi Marak and Nokrem Nanjan Sangma. During inquiry made by Musadar, some clan people numbering about 15 gave their consent by writing supporting the proposal. Sri Nanjan Sangma and his wife, being the Nokna of the deceased Nokmas, have legitimate right to inherit Nokmaship according to custom. On inquiry, nobody raised objection to the appointment. I therefore appoint Sri Nanjan Sangma and his wife Batmi Marak as Nokmas of Dokigre Amite Aking 4/50/12.
And what happens?
Your Lordship, I will, may I give the GT. Your Lordship, the order dated 18/3 had a point. Batmi Marak, Your Lordship. Batmi Marak is the
Yes.
Batmi Marak is the mother of the petitioner.
But it's Ongen. Ongen Samari or he's a
Shra. He's a Shra. Onjan is a Shra.
Then he's a mother. You said this
Petitioner number 3. Ranjan B. Marak.
Number 3, Ranjak. He wants to be Nokma now.
He's the Nokna.
He's the Nokma now. Srimati. Ranjak.
Ranjak B. Marak. Petitioner number 3. Petitioner number 2 is the petitioner number 2 is the husband of the petitioner.
She's the daughter of Batmi Marak.
Yes.
Okay. Ranjak Marak. That is petition number 3. Daughter of recorded Nokma of 1983.
Yes. And thereafter, Your Lordship, on the death of Batmi Marak, the petitioner number 1 had filed an application for appointment of Ranjan B. Marak, petitioner number 3.
Yeah.
Your Lordship, the application is at page 17.
Okay.
Prayer for appointment of Sri Goyan Sangma, who is the petition number 2, husband of Srimati Nanjan Marak, as Nokma of Duke Aking. And thereafter, Your Lordship, the private respondent had filed a complaint against our application. The application is at page 19, Your Lordship. May I read the complaint, Lordship?
Yes.
Sir, we with due respect informing you by this petition that Shri Ranjan Marak and her husband Shri Goyen Sangma have applied before you for registration of Nokma of Duke Aking Amite. In this regard, we are informing you that they are not the successors of the Aking. The successors of Aking are Shri Nonen Marak and her husband Shri Jonen Marak. The mother of Nonen Marak is late Mipan. After the death of Rikse, Nokma Mipan was given as substitute wife to Dindrang Nokma. Thereafter, we clan people, we not allow Shri Ranjan Marak and her husband Shri Goyen Sangma to register as Duke Aking Amite Nokma. Your Lordship, is pertinent to mention, Your Lordship, that Srimati Nonen Marak is Poljuni Marak's sister.
Now see one thing, is they say that the successor Aking are Nonem Marak and husband Jonen Marak.
Yes, yeah.
The mother is late Maipan. After the death of Rikse, Maipan can substitute to
Batmi Marak. Your Lordship, they did not file any objection to the order 1983.
Now Rikse Marak was before Batmi Marak.
Kamse Marak and Rikse
See, Rikse
Marak
Marak was, then Batmi was a Nokma also, 83, correct?
Yes, yes. She is the.
Then how can they raise objection now that,
Yes.
that is substitute wife of Rikse at that time now? Then what about the succession of Rakmi then? Of Batmi, sorry. Makes no sense.
Yes, Your
How can they object now this stage in 2005 to say that, that my grandmother, whatever was.
Since my friend is relying on the genealogical tree, my lord, it will be proper to examine the record also. Record will be very much needed, my lord. Here, my lord, they are against the order of delay. The code, the appellate code has condoned the delay, my lord. And my friend is not into the delay part at present, but she is onto the facts of the case. For the facts, my lord.
What was the delay? With the application for delay.
My lord, may kindly see. My lord, may kindly see.
The private respondent had filed a objecting the order 1983, Your Lordship. There was
Where?
My lord, may kindly come to page 65.
Well, come there straight away.
Yes, my lord.
Yes.
Now, my lord, may kindly see the third line of the last third line, my lord. Delay therefore prayed for condoning the above delay to file an appeal against the order that is allowed. Only the delay has been condoned, my lord, to file an appeal. It is not the case, my lord, where the appeal has been decided. If we are going to the facts, my lord, if we are going into the facts, my lord, then record will be very much pertinent, my lord.
By Your Lordship,
Just a minute, please. Here, the delay was condoned to allow them to file an appeal. Now, my lord, to allow the delay or not, or to condone the delay or not, my lord, it is a prerogative of the court, my lord. How they can come against this order, my lord? And there is an order of this honorable court, my lord, where the CEM has the authority to condone the delay. But my friend is going into the merits. Now, if she can show, my lord, the delay was not proper, or the dates which has been delayed.
Only one thing is that, see, how many days delay are they talking about?
40 years, 5 months, and 5 days. Your Lordship, I have a judgment regarding.
Did you file objection to this?
Probably they have not filed.
Yes, Your Lordship. This is yes, Your Lordship.
Were you heard? Okay.
Yes, Your Lordship.
My lord, may kindly see. My lord, may kindly see.
One second. Let's see.
Paragraph 10, my lord.
Lordship, if you come to paragraph 10, Your Lordship, they have cited a citation, and the CEM, Your Lordship, has cited a citation, Rahim Shan and another versus Goyen Singh. Your Lordship, is pertinent to mention, Your Lordship, this ruling, Your Lordship, there was a continuation of delay of only 52
See
days.
what? I'm bringing the order. Why is the reason for the condemnation? See, condemnation is exercise of discretionary power.
Yes.
And normally, court sitting and revision or an appeal will not, interfere out of condemnation. Only if it's, totally against the principles of law, or if it's in the face of the record, it's become very offensive. Let's see the order. Read the order. Read the whole order. Read it. Not long order. Read it. This page 63. Just read it.
That due to this above consideration.
No, read from the beginning.
Page 63.
This court has not read the papers like you have read prepared. So please read it.
That the appellant's petition
One thing
highly.
that would advise to counsels now. When you place a case, just imagine that you're telling a story to a person who doesn't know anything. Suppose you're meeting a friend to describe an incident, what happened. So that friend does not know what's happened, or your parents, whatever. You come back and say this happened. You can't just say this and this fellow got kicked. Then you can't expect the court. So you have to you tell your case like as if the person was nothing, and how you make them understand in the most simple terms that these are the issues, this is the question, and this is what we want. That's just make it simplified. So for arguments, I notice they think that the court knows everything. That this order so you read the last line. It's like that. Yes. We have tons of files to read. We don't read the hearing files, so only we expect assistance from the lawyers. Yes. Read or 7824.
That the appellant's petitioner being highly aggrieved by the impugned order dated 21/8/2023 of the Deputy CM in charge of Revenue, GHEDC, Tura, henceforth lower court, past GDC Revenue number 96, AC of 2004-05, present this appeal on 18/9/2023. Even though there is no delay in appeal against the order dated 21/8/2023, but since the appellant also seeks to appeal against the order dated 13/4/1983, hence this prayer for continuation. The appellant's counsel also submit that the appellant number 1 is related by blood to Nokma's family, since her grandmother, that is late Kamse Marag, was an elder sister of late Rikse Marag, the Nokma Michik of Dokigre Amite Aking. After the death of Rikse Michik, Nokma clan people of Dokigre Amite Aking had substituted late Mipan, mother of the appellant number 1, to Duran Sangma Nokma. Then the EM in charge of Plan and Revenue in GDC Revenue case number 33 AC of 1982-83 had passed the impugned order dated 13/4/1983 behind the back of the petitioners. In this order, EM had directed for registration of late Bagme Marag and Linden Sangma, parents of the respondent number 2. They are not related to Aking in any manner. Late Batme Marag and Ninjan Sangma, parents of the respondent number 2, never become Nokma even after the alleged order, and no one from the Aking knew them or recognized them as Nokmas. During this period, this Aking is being looked after by Sri Gawan R. Marag, Nokma of Darat Aking. They have not been officially registered themselves as Nokmas, and no oath taken certificate were clearly declared them as Nokmas. Their name have not been GT of Dokigre Amite Aking. However, this appeal is needed since, as per Garo custom and practices, Nokmaship can be succeeded by daughters. It is also submitted that the present petitioners and their clan people have been fighting this case since 2004, initially through her sister Srimati Nonin Marag, though they did not directly appeal against the said impugned order, but that is due to their ignorance and due to ill advice of their elderly counsel. Hence, there is a delay of 21 years counting from 1983 to 2004 are considered then 7,665 days altogether, but this order is really hidden from the petitioners. They have no knowledge about the existence of this order, hence 7,665 days are protected in view of Section 17 of the Limitation Act. Against the period of delay from 2004 to 18/9/2023, that is 7,019 days, are again protected in view of Section 14 of the Limitation Act. That in reality the delay had been occasioned from 13/4/1983 to 2004, which is about 21 years. But this case began in the court of EM only, not in the appellate court, which is due to ill advice of the lawyer only. Hence, no negligence nor inaction nor bona fide can be impugned to the petitioner. Hence, deserve for liberty construction of the section in order to advise substantial justice to the case which are beyond the control and power of the petitioner. That the Honorable Supreme Court has issued guidelines in case reported in case between N. Balakrishna versus Krishna Murthy. Supreme Court also held that the word sufficient cause in Section 5 of the Limitation Act of 1963 should be construed liberally. Acceptability of delay is the sole criteria and length of delay not relevant. Moreover, the denial of prayer of condone the delay would amount to deprivation from seeking justice on merits. If delay is not condoned, the right as are available with the petitioner would be scuttled. That in the matter of considering of prayers to condone the delay of learned court is not accepted to seek mathematically precisions and also should not be hypothetical. As a matter of practice, acceptance of explanation furnished should be rule and refusal an exception, more so when no negligence or inaction or lack of bona fide can be impugned to the defaulting party, hence prayed for condoning the above delay. The counsel for the respondent opposite party argued that the petitioner is not maintainable petitioner should have filed for review or revision within the appeal period only, but they failed to do so. Section 5 of the Limitation Act is not applicable in this case. Moreover, the Limitation Act is not applicable in the tribal area, but they are bound by the statutory law itself. Petitioners should have filed this appeal in the year 2004 itself when they bring the case before the court of the EM, but they did not do so. Hence, doctrine of waiver and acquiescence applies against the petitioner. Moreover, the Limitation Act is applicable before the regular court only and not before any body exercising quasi-judicial function like the present court. They are bound by statutory law only. Due to this reason, and since the delay had been occurred when is inordinate and excessive, hence prayer ought to condone delay to file an appeal against the order dated 13/3/1983 may kindly be dismissed only. Having heard the parties at length and on perusal of the case record, it is also clear that the applicants belongs to the original Aking Nokma family, which is not even deemed denied by the opposite party during the hearing, but praying the dismiss this case on technical grounds, especially since the delay is indeed too excessive and occurred inordinately. This excessive and inordinate delay is a real concern. However, when the parties are litigating with regard to the rights over the immovable properties like Aking itself, and when the petitioners are claiming to be from the actual Nokma family, therefore the substantial rights need to deceive between the parties, and if the delay is not condoned, then as per Garo custom and practices, parties can claim succession after their parents. That due to this above consideration, self also relying on the Supreme Court decision in Civil Appeal number 4628 of 2023 arising in special leave petition civil of number
between so and so, yes.
Decided that in order to consider the matters on merit and do substantiate justice to the parties, delay ought to condone when there is no malafide intention by the petitioner and he does not stand to benefit by lodging an appeal late. Supreme Court also noted that if delay is not condoned meritoriously, matters would be thrown out at the very threshold and cause justice being defect. Even every day's delay must be explained does not mean that a pedantic approach should be made by taking account why not every hour delay, every second's delay, etc. But doctrine must be applied in rational, common sense, pragmatic manner only, since there is no presumption that delay is occasioned deliberately or on account of culpable negligence or with a malafide intention to gain any benefit out of this delay. Therefore, prayer for condoning the above delay to file an appeal against the order dated 13/4/1983 is allowed. Based on the above observation, dismissed case is therefore disposed of accordingly.
Now, only one thing, MSAM, has the name of this Batme been entered in the geographical table?
Yes.
It's been entered. Produce the record. If it's been entered, we won't allow the condemnation. Has it entered the GT?
That's what my lord I said on the
which annexure?
GT is a page 1, my lord. Annexure 1. But the type copy is not there of the GT probably. You've given
it's there.
GT is there, my lord.
Where is it?
It's page 13.
Well,
No, this is not. No, this is not
Lordship, there is
GT.
no GT,
There
but
is no
there's
GT, my lord.
there's an order. An order by.
So that means this Batme Marak also never was an Nokma then.
But there's
That means evidence has to be taken in this matter.
no, no, Your Lordship, evidence has.
No, the thing is that, see, one thing, now if Batme Marak, by the order 83, they did that order 13,483, correct?
Your Lordship, if you
Had
come
taken
to-
over the office of Nokma and her name entered in the GT, then there's no question of any condemnation.
Your Lordship, if we come to order 21/8/2023, Your Lordship, page 21.
Yes. Interesting matter. No, this order is yes, but whether on the basis of this order did she ever take over Nokma?
Your Lordship, they had appealed this order, Your Lordship.
No,
This order
the appeal is order.
along with 1983.
That's not
at present,
that isn't 04. That is 1004 they did it. That time between 83, when the order was passed on
13/4/1983.
Yes, 13/4/1983. After the order was given in your favor on the in the predecessor interest, that means respondent 3's mother, the petitioner 3's mother. Did she assume office? She and her husband as Nokmas.
Yes, Lordship. There should Nokma Aking cannot be remain.
No, did they assume office or not?
Yes, Your Lordship.
They did discharge the function of the Nokma.
Yes,
Now, if they have done that,
Now their allegation is what? Simple. That okay, due to ignorance or not, they cannot challenge at that point of time. But even after the order, which was passed, was it passed ex parte, the order for Batme? Giving her, recognizing her.
it appears so, my lord. The condonation order appears so.
So the
my
thing
lord.
is that their stand is only that, notwithstanding the fact that the order was 83, coming to the facts on the ground, Batme never took over as an husband as Nokmas of this, what's the King? Doki Giri King. Right? Doki Giri actually, King. That is their stand. And the CM on this consideration has said, okay, fine, they're allowed to find appeal. Now you contest the appeal then. Well, out here you have not come challenging the appeal, correct? No order has been passed. It's only in condemnation matter. You understand that condoning the delay of 7,000 days plus or 14,000 days, it's a very serious matter. But in this case, the thing is that if you could show some material that after 13,483, you know that.
But one more thing that my lord has to examine, Batme Mara, whether she was a substitute wife or not, my lord.
No, we will not examine that.
No, my lord. If
see, look at this report 83. The Mozdar's report seen so Nengan Sangma so Batman and client people. So whether at that point of time, this Rikse, after she died, substitute wife, something, those are totally different things altogether.
No, why I am saying so, if she was a substitute wife, my lord, that order need not be challenged. The moment she died, my lord, she relinquished the right. Their children's.
The moment
she died,
Rikse died,
Batme, right. So she relinquished, my lord. That order need not be challenged. Then, my lord, the original Nokma's daughter will take over, my lord. That is what, my lord.
But the thing is that they are saying that Batme never functioned as Nokma. That is the thing.
For that, my lord, we have to examine the record. And one more thing, my lord, if my lord may kindly peruse the ground that they have taken, objecting the order of the CEM, my lord. That probably, I feel, my lord, it is given in page 9.
Yes.
What was the ground? Why they are aggrieved, my lord? In brief, why they are aggrieved? They said, my lord, 7, my lord, para 7, page 9. That the petition, Miss Case number so and so under section 5 of the Limitation Act cannot be invoked before statutory body performing quasi-judicial function in appeal or application as under section 5 cannot be invoked
No,
also.
see, the thing that they function on the principles of justice, equity, and
Yes, my lord. Now,
so that's the thing. So that
now
we're,
if
not,
my
we're not
lord-
looking, we're not looking technicalities. We are looking to the fact of the case itself. That whether, but we're not going to have to enter into the merit whether Batme was the Nokma or not.
if this is the only ground that my friend is highlighting, then my lord, this ground cannot be allowed, my lord.
Yes.
So we'll call for the record, my lord. My lord, we'll call for the record and then we'll examine the record, my lord, whether she has performed or not, whether there is an order allowing her to perform the duty or not. Because there has to be an order.
At some length, they've seen that the records of the connected records are necessary to produce by counsel for respondents. So only called for the records just after 2 weeks. We'll see if they're not GT, then discretionary power will not, even though it seems very.
The days which has been condoned is disturbing, but very disturbing. But the fact is this: whether there was a ground to condone or not.
Only one matter.
Your Lordship, I'm seeking some accommodation, Your Lordship.
Why?
This matter on behalf of Mr. Paul, Lordship.
He's ready.
Lordship, this is that matter where we're challenging the KCDC Act also. Amendment Act.
Lordship, it's a special counsel in this case, Your Lordship.
Who's special counsel?
Mr. Paul.
None, Mr. Jindal.
Mr. Paul, Lordship.
So,
he's not in town.
So,
No,
Paul
Your
is
Lordship,
appearing.
it's station.
Okay. When do you want it?
Subject to Lordship convenience or any time.
After
Lordship,
Diwali.
or else-
How to do it there?
Oblige.
Obliged also.
Mid.
61.
Weather's getting a bit chilly now.
Yeah, it's chilly. It's very chilly.
Change. Yes.
Sudden change.
Where were we?
Yes, Your Lordship, the application was moved by the respondent for vacating the interim order, my lord.
Yes.
And my friend has advanced the argument on last date of hearing.
Yes.
I have filed the reply to his application, my lord. That is also on record. And I have also filed application to amend the writ petition. Amend
the application?
Writ petition. My writ petition, my lord, because
have they been given copy?
Yes, copies have been supplied in wave.
Do you have any objection to the amendment?
Yes, yes.
Yes. Lordship first. Am I audible, Lordship?
Yes, very clear. Yes, visible, audible, everything. Yes.
Yes, Lordship.
Yes.
What I'm trying to say is that amendment will only be if the writ petition initially is maintainable. So let us see whether it's maintainable.
Yes.
Because there are certain documents.
Yes.
So let us first agree.
Yes.
So therefore, the amendment.
Yes. No, but you have received copies, correct? You have received copies of the application, right? Okay. Right. Okay.
Now the issue is, my lord.
They have, you see, they have made those points.
Yes, I have. I will deal.
Points,
yes, my lord.
Like Mr. Goswami has collated that day.
If I summarize the argument of Mr. Goswami, his argument is that the MEPDCL is a government company, and government companies are covered under the IBC code. That is first argument. Second argument is, my lord, that the respondent, that's a petitioner, MEPDCL is not discharging sovereign function.
No, first that MEPDCL is not a corporate entity.
It is a corporate entity, my lord. Okay. And if it is a corporate, I do not disagree, and I hope Mr. Goswami will also not, because if I am not corporate entity, my lord, I will not come under the IBC code.
Right.
No, my objection was not this. My objection was that in the writ petition they have suppressed the fact that they are a government company.
Okay.
Therefore, that suppression has to. That was my argument.
Okay.
In the writ petition, nowhere they have stated. Rather, they have stated that they are not a corporate entity.
Okay. Yes. Please.
That was their statement in the writ petition. That was my objection. And I had also said, at ground C, page 9 of the writ petition, where they specifically stated it is not a corporate entity. Today it is making a U-turn.
Okay.
Now, so that is the first argument. If I am correct, that is the first argument. And the second argument is, my lord, that IBC code is applicable to government companies. Yes. Alternatively.
Yes.
And third is that there is an alternative efficacious remedy against the order of NCLT.
Why don't you avail order remedy?
No, I will answer, because I am.
That is a very crucial factor.
Yes, all these I am grateful, my lord. These are the three issues, and if your lordship will see, I am grateful to my friend also that he has cited embassy, that judgment. So that therefore, my lord, now why? First question is, my lord, why the NCLT has no jurisdiction so far as the petitioner is concerned, my lord. If it has jurisdiction, then that's a different issue. If it has no jurisdiction, then it has a different issue, my lord. So my submission is that NCLT has no jurisdiction so far as the scheme is concerned, the projects are concerned on MP and in respect of MEPDCL, my lord. Because your lordship will keep in mind, is a government company which is distributing electricity throughout the state. It is, our case is that it is an extended limb of sovereign function.
Okay.
If it is extended limb of sovereign function, my lord, in embassy judgment, the Honorable Supreme Court has held that IBC code is not applicable.
But then sovereign function, they've classified exactly, it's defense, it's,
No, my lord, even NHI, your lordship has seen NHI.
Okay, HEC is different, but they have made it very clear.
Yes, my lord,
as what will constitute matters of national importance.
I'm grateful, my lord. That is, I have to show the relevant paragraphs and pages of that judgment to show that sovereign functions of all kind are outside the ambit of the IBC code.
Okay.
Sovereign functions of all, because assuming, my lord, for the sake of argument, if my friend's argument is accepted, that will be that now the IBC does what? There will be interim resolution professional. He will sit on the body. He will sell the assets and he will pay the dues of all persons whose debts have not been paid.
Okay.
Then the question is of supply of electricity to the common people. Therefore, it is a kind of sovereign function, and in Meghalaya it is a sovereign function, because in other places, your lordship, will have, there are private entities.
Yes, the suppliers.
Supplier. Here in Meghalaya, there is no such entity. It is a sovereign and sovereign function alone. But before I proceed, I am ready with the matter, my lord, because why I make this submission: if this interim order is vacated, my writ will become infructuous, because IRP will be appointed. So therefore, if my friend is inclined to get the matter adjudicated at this stage only, because I have to show this much, that I have a prima facie case as of now, Miller, to maintain the interim order. Indeed, if my friends want to file reply, counter, rejoinder, I am ready to argue on the main matter also.
No, the thing is that, see, what, if my understanding,
yes,
that time when we was moved,
yes,
what was put for the court was that NHI judgment, regarding,
yes, and that judgment
on that prima facie satisfaction, we said okay,
yes,
like we passed some restraining orders.
Yes,
but now they have come for vacation.
In NHI judgment also,
you address the point.
Yes, Miller, I'll address the point.
The main task is that this represents maintainable.
Yes, my lord.
So the court's open to that. We're going to hear.
Yes, I'll. NHI judgment also, your lordship has seen. In NHI judgment, my friend has read out certain paragraphs where, in respect of NHI, the court said that it is discharging the sovereign function. The Honorable Supreme Court held that it is discharging the sovereign function. There were other petitions by NTPC and other parties. In those petitions, my lord, what was the issue? There was a arbitration award. There was an arbitration award and in that context, because, my lord, as a MEPDCL, I have got certain duties as a sovereign. I am discharging certain sovereign function, and there are certain duties. For example, I am buying some transformer. If I am buying some transformer, I am unable to pay. Probably for that role, I may come under IBC code. But when I am implementing the scheme of Government of India, or government of state, I have no independent power, Milan, and it has got bearing under IBC code also, Milan. Because what is required for the law, or for me to come under IBC code is, Milan, is that debt should become due and payable. I'll briefly show the law and I'll deal these provisions in detail at later stage.
Yes.
But lordship may take note of certain provisions of IBC code. And kindly see the first provision, that definition, my lord.
Yes.
First is 3 subsection 7. Corporate persons mean a company as defined in clause 20 of section 2 of Companies Act 2013, a limited liability partnership as defined in clause N of subsection 1 of section 2 of limited liability partnership, or any other incorporated with limited liability under any law for time being enforced, but shall not include any financial service provider. So on that basis, my friend has said I am a corporate person because I am a company defined under section 2 of the Companies Act. Now your lordship kindly see corporate debtor. means a corporate person who owes a debt to any person. So your lordship will have to take note of corporate debt. I owe a debt to any person. They have to show. Then debt is defined, my lord, in section 311. Debt means a liability or obligation. A debt means a liability or obligation in respect of a claim which is due from any person, includes financial debt and operational debt. So lordships kindly mark this, in respect of claim which is due from any person. So due has to be there. If it is not due, then it is not a debt.
Yes.
If it is not due, it is not a debt.
Yes.
Default, my lord, now default, because these are the basic requirements. Default means, again, my lord, non-payment of debt when whole or any part or installment of the amount of debt has become due and payable. So debt has to be due and payable, my lord, and is not paid by debtor or corporate debtor, as the case may be. So the IBC code will kick in or will come into play when debt is due and payable. If debt is not due and payable, it will, IBC code has no application.
Okay.
So first requirement for application of IBC code is to show that IBC code, as per the facts of the case, this debt has become due and payable. And this debt has become due and payable. Now, my lord, kindly see section 8 for completeness. No, sorry, my lord, kindly see section 5, subsection 21, operational debt, because it is their case that it is a operational debt. Because 5 starts from corporate. 5 starts corporate applicant, corporate debtor. He is a, and 522 is 521 operational debt.
Operational debt.
Yes, operational debt means a claim in respect of provisions of goods or services, including employment, or a debt in respect of payment due arise under any law for time being enforced and payable to the central government, any state government, or any local authority. So it classifies this operational debt, covers the debt to the companies, debt to the central government, debt to state and local. So the provision is in respect to provisions of goods and services, including employment. So the case of the respondent before your lordship is that it provided certain services and material to MEPDCL to simplify their case, and in terms of that supply, that debt became due and payable. That debt was not paid by me. I am arguing against myself, my lord, for this, and there is a default. That is what their case is, my lord. Now kindly apply the principles in the facts of the case, my lord. What is their case?
Yes.
Their case before lordship, kindly see the impugn order itself. What is their case, my lord? At page, for the sake of convenience, my lord, what I have done is that in my rejoined the amendment application, I placed all the documents, my lord. So kindly see the.
Can you refer to that at this stage? Is that come on record as
Yeah, I have filed it, and it is miscellaneous number is there, my lord. For the sake of, I could have supplied separately also, my lord. For the sake of, and they have a copy also. Because convenience will be there, my lord, because your lordship will not be required to refer to any other. Then kindly come to page 18, my lord, of this volume, my lord. 17 and 18. Lordship will see, and kindly see the submission of submissions at page 18. This before the NCLT, my lord. Their own case before NCLT. Paragraph 2.3. In the month of January 2019, operational creditor was awarded 2 contracts under the Saubhagya scheme. My lord, kindly mark this word Saubhagya scheme. through two separate work packages for supply, erection, assembly, manufacturing, type testing, loading, transportation, uploading, insurance, delivery at site, handling and storage for execution of work under the Saubhagya scheme in the state of Meghalaya, specifically for construction of 11 kV single circuit line for 100% household electrification. Pursuant to instruction from corporate data, the following contracts were inserted. Package A, 2 supply agreements dated 4/3/2019. Package B, 2 supply contract agreement dated 2/9/2019. So this was the contract under the Saubhagya scheme. These are the, my case is that this scheme is scheme of the central government, and the scheme, your lordship will, I'll take your lordship to the scheme and the provisions. The scheme will show that the entire thing was being funded by central government, state government, and MEPDCL was liable to make the payment only when central government or state government clears the dues. So this is not a debt on MEPDCL.
Okay.
This is not a debt on MEPDCL, my lord.
Directly.
Directly.
Directly is on them, but indirectly is not.
Because the admitted case of the respondent or the applicant before the NCLT is that these contracts were entered under the Saubhagya scheme. So if he is entitled to payment, he is entitled to payment under the Saubhagya scheme only, my lord. Debt will become due and payable under the Saubhagya scheme only. I will show the pleading, I will show how the tribunal has dealt with this aspect also, because for completeness. Now if your lordship will kindly see the Saubhagya scheme, because their own case is Saubhagya scheme, my lord. 439 at page 439 annexure 2. The Saubhagya scheme is there, my lord. प्रधानमंत्री सहज बिजली हर घर योजना सौभाग्य. Keeping in view of the role of electricity in human and socio-economic development, Government of India has formulated a scheme to ensure last mile connectivity and electricity connection to all remaining unelectrified households in the country. Sanction of the President is conveyed for launch of Pradhan Mantri Sahaj Bijli Ghar Yojana Saubhagya to achieve universal household electrification in the country at a total cost of 16,320 crore, including gross budgetary support of 12,320 crore from the Government of India during the entire implementation. So 12,000 rupees will come to 320 will come from central government. The details of cost estimate enclosed. The objective of the scheme is to achieve universal household electrification by providing last mile connectivity and electricity connection to all households, all discoms, including private discoms, state power departments. May Lord kindly mark, state power department, rural electric cooperative societies shall be eligible for financial assistance under the scheme. The states which have already taken up household electrification program on their own will also be eligible under the scheme from date it comes into vogue, provided that the scheme is aligned with Saubhagya follows all guidelines. Funding pattern, my lord. The states have been categorized in two groups: a special category states, all northeastern states including Sikkim, J&K, Himachal, Uttarakhand, and other special category states, all other states, the Union Territories, Andaman, Nicobars, and etc. Now, my lord, for me, the category financial support is Government of India, my lord. We are in the category of 85%, my lord. That your lordship will find. Now, paragraph C, my lord. Kindly see paragraph C of this. State duties are required to complete the work of household electrification by 31st March 2019. However, additional grant as indicated in serial number 4, 50% of loan component, 5% of special category state, 15% of other states under the scheme will be released subject to achievement of 100%. And I fall, my lord, in 85%. If your lordship will find that in column 5, financial support. So I am getting up to 90%. I am in special category states, my lord, and I am getting all northeastern states. Your lordship has seen I am in all northeastern states, 5 funding pattern, all northeastern states including Sikkim, etc., my lord. So I come under northeastern states, and to do all that, to the extent of 90% fund will come from central government, my lord, for this.
Respect, Lordship, before the AG continues. I have
Yes.
not easy arguing the judgment on merits.
No, he's trying to show whereas. Let him continue, doesn't matter. Yes.
He is
Yes.
now, the learned AG is now saying that debt is not payable by me. Those are the issues to be decided by the appellate forum.
I'll show.
Let him continue. Yes.
I'll show everything. I'll show.
He is now arguing in the merits, Lordship.
No, I am just showing that it is a sovereign extended limb.
No, see, Mr. Goswami, let him continue. We'll just delay the matter unnecessarily. He's trying to show where the pipeline is coming from with regard to show that it's not, a debt that is on the corporation itself. That's the only thing.
Now, the issue is pinches.
If he has to argue on merits, he has to go to the appellate tribunal.
Yes.
No, I'll deal with that aspect. Why this?
Okay, please continue
yes, my lord. My lord, kindly see. Bits of interruption is also
useful.
Useful, my lord. Now, my lord, kindly see your lordship has seen 439 where the Sabhagya scheme is there, my lord.
Okay.
Then your lordship will kindly see guidelines framed under this scheme. They go to the central government for money. I didn't want to raise that issue, but unfortunately, I didn't want to go into the controversies. What they have done is very unethical on their and the client's part, my lord. That they have written to Prime Minister office saying that I have obtained the stay by misleading, etc., and that complaint has been filed. I'm really pained and that complaint, and they say, if your lordship, I don't want to go into that issue because I have a good case on merit. I don't want to enter into that.
Later, they have made a complaint
yes,
to the PMO.
Yes, and that
proceedings for this court.
Before the court, and saying that I will continue the stay for I don't know how. And
who will come to stay? The government.
Yes, me and the court. If your lordship will see this, I'm really sorry to say, my friend is very. Yes, I am 568, my lord. Kindly see. I will show this. Let me see, because I don't want to go into this.
No, okay, continue.
Yes,
we'll tackle that later.
Yes, later on. Because I have good case on merit. I don't want to go into all those arguments. Now, kindly see the guidelines at 447, my lord.
Yes.
In continuation,
because we're still on the point of jurisdiction, remember.
I'm only jurisdiction. I'm only jurisdiction, my lord. I will not touch merit. Yes. I want to show that I am this function was function in extended limb of sovereign function, and if it is extended limb of sovereign function, no debt is payable, and no debt is payable, then there is no IBC code.
Okay, yes, continue.
Yes, my lord. No other argument, my lord. If I have no case, I will take liberty. I will go to appeal, and my remedies are also there. It's not that, but I'll show that there is no jurisdiction. 447. In continuation of Ministry of Power, or even number of 10 notifying the Saubhagya scheme, undersigned is directed to forward yet operational guidelines. Now kindly see this operational guidelines, which is very relevant, my lord, and permit me to place the entire guideline, because this is the guideline under which payment is being made. As per census 2011, out of 160 lakh rural household, my lord, page, lordship has the page 447.
Yes, 448.
Yes, 448. Yes, my lord. As per the census 2011, out of lakh rural household, 92.8 lakh rural household were using electricity as the main source. Listing of 750 lakh household were reported unelectrified. After 2011, free electricity connection to BPL household were released under the erstwhile scheme, as well as present Deen Dayal Upadhyay Gram Jyoti Yojana, my lord, scheme. Your lordship, why I am showing it, that there is some claims are also arising out of Deen Dayal Upadhyay Gram Jyoti Yojana scheme. Also, the states release connections under their own scheme as usual applicable charges as per data provided by state. Out of so and so lakh rural household, are electrified. Remaining 460 lakh households are yet to be electrified on 30th April 2017. State-wise details are enclosed. These details have been further updated by states, and updated details on 10th October 2000 are also enclosed in Annex 2. About 170 lakh households already sanctioned under DDUJI are yet to be provided free electricity connection under the scheme. In urban areas, as per Census 2011, 57% were not using electricity as a primary source of lighting. State-wise details are in Annex 3. Accordingly, about 50 lakh households in urban areas are expected to be unelectrified, which are expected to be economically poor. Keeping in view the role of the electricity in human and socio-economic development, Government of India has formulated a scheme to ensure last mile connectivity and electricity connection to all remaining unelectrified houses in the country. The objective of the scheme is to achieve universal household electrification by providing last mile connectivity and electricity connection to all households in rural and urban areas through financial assistance, DISCOMs, Power Department and Government of India. Approval scheme, Government of India has launched Pradhan so and so. The amount your lordship has seen. So under this scheme, my lord, who are eligible entities at phase 450, my lord? All DISCOMs, because there is a tripartite agreement between the state of Meghalaya and all DISCOMs, including private sector DISCOMs, state power departments, your lordship, and rural electric cooperative societies shall be eligible for financial assistance. My lord, kindly mark, because we have written this assistance has come from state power department only, this eligible entities. Now, scope of scheme, a lordship has seen. I will not. This is the scheme under which so the eligibility is of the DISCOMs, state government, and proposal will come from the state government, my lord. That is also there. Now, kindly come to page 457. Proposal, my lord, 457. Proposal. DISCOMs / power departments to indicate FI bank approaching, implementation of plan and certificate and undertaking, etc. 100%. So these are the requirements under which the scheme was being implemented. So these two documents, my lord, the Pradhan Mantri and under this Saubhagya scheme, my lord, for short and DDUJY.
Okay.
The entire scheme is envisaged by the central government. State government is the authority, and for that purpose, your lordship will kindly see (525). No, sorry, 524, 47. Yes. Then, my lord, we have written then the I have shown only one more aspect, my lord, that this was the loans were sanctioned and etc. My lord, sanction is 542. 542. A lot, you kindly see 5. $542. Your lordship has 540. Has given 5.
Yes.
Yes. 542 is the document of REC. Additional, and it is addressed to Ministry of Government of Meghalaya, my lord. Project for providing last mile connectivity under so and so rural household, rural so and so. This has reference to the proposal and DPR submitted by the state for consideration of sanction of so and so for electricity 1,876.3515 crore for household and under Pradhan Mantri Sahaj Bijli Har Ghar Yojana Saubhagya scheme for universal house. The monitoring committee in its meeting held on 9th July 2000 has approved the project cost of 275.73 crore rupees for so and so household and the amount it comprises 200 for grant and balance is 20 for is utility contribution. Last line, Your Lordship.
Yes.
The approval is subject to terms and conditions set out in Annexure 2 and operational guideline issued by Ministry of Power. So this is what they are saying, that it is a debt due and payable by me.
This time we trace that the source of that is not anyway.
Yes.
It's not a business venture on your own accord.
Yeah, this is not a, this is a sovereign function which I was discharging on behalf of the central government, on behalf of the state government, and for that I am showing 3 documents. I have shown, my lord, the Saubhagya scheme, guidelines, the sanction, even, my lord, this was placed before the agreements also, and even in Lok Sabha it is. So therefore, when I am discharging a sovereign function, you cannot put me in that category where you say that no, you are liable to pay. Kindly see the Lok Sabha question also, because this came in the Lok Sabha also. This issue came in Lok Sabha also, and at page 449. 449.
What relevant? What?
Because this shows that the scheme is of this scheme and everything is being controlled. Because what I am trying to demonstrate with the help of these documents, my lord, is that this is 494, I am sorry, my lord, 494. This is not the baby, or this is not the debt payable by MEPDCL. And whatever direction is passed by state government, central government, I am bound by those directions. And therefore, debt did not become due and payable, my lord. Lordship, this is the statement of Government of India at the floor of the House, my lord, at 495. These questions are there. Aim and objective of Pradhan Mantri Sahaj Yojana, Saubhagya, and type of assistance being provided by government to achieve the objective of scheme, whether government has fixed a deadline for completion, the names of state with whom agreement have been signed, and scheme and names of the state which have forwarded the proposal report now under the scheme, whether the ministry has entrusted the Department of Posts, etc. budgetary Saubhagya scheme, my lord, and then reply, my lord.
Yes.
The Government of India has launched Pradhan Mantri Sahaj Bijli Ghar Yojana Saubhagya, and outlay of so and so crore rupees. Lordship has seen for universal under the Saubhagya scheme. Government of India provides budgetary support to the extent of 60% and 85% for special category state. I fall in that, and additional budgetary support of 15%, 5% for special category. 90% is, my lord. We are for available achievement of 100% house. So all remaining unelectrified household targeted by 2024 states have submitted their letter of intent of Agya, including, my lord, kindly mark, Meghalaya. Meghalaya. So this 9th state is now 3 also, my lord. The Ministry of Power had asked the Department of Post for survey, etc. and so on. So this is the scheme of, my lord, this is the scheme of Government of India, which we have followed to the hilt. And the letter has also been sent by, because REC was the executing agency, my lord, for the Government of India. So that letter, your lordship, will find at 536.
Okay. Anything else on this?
On this issue only, my lord. So I have shown, my lord, the scheme, this Lok Sabha question, the DD. Now there are certain agreements which have been signed, which are of tripartite agreement, in which Government of India is
a party.
Sorry, Government of the state government is a party, my lord. State government is party, because that agreement, your lordship, will find DDUJY agreement at 525. Just give me 525. Yes. 525, your lordship has 525.
Okay.
And that is 525 is there, my lord. Kindly see 30th November 16. that rural electrification, Government of Meghalaya and Meghalaya Power Distribution. And your lordship will notice also that DDU in the bold part at 526.
Okay.
So this is the project of the Government of India, Government of Meghalaya, and this is not a date, and they knew it is a Saubhagya scheme. They knew they have acted under the Saubhagya scheme throughout. They have examined it on that ground only. Now, my lord, kindly see my submission before the NCLT on this line. My argument that your lordship will find at page 397.
Yes. 397?
Yes, 396, your lordship. Before NCLT.
Three
396. This is paragraph 7. The applicant has been created by the statute to function as an extended limb of the state government. Electricity falls under entry 38 of list 3 of 7 schedule to the constitution. In case of Chameli Singh versus State of UP reported in AIR 1996 SC 105, Supreme Court had cited right to shelter includes adequate living space, safe and decent structure, clean and decent surrounding, sufficient light, pure air, water, electricity, sanitation and other civic amenity. So electricity is a fundamental right. This fundamental right cannot be discharged by IRP. It is a sovereign function. These judicial proceedings, President established that electricity is basic right which has to be provided by the government. Now, 9. Meghalaya State Electricity Board was constituted under subsection 5 of Electricity Act of 1948 by Government of Meghalaya by notification number so and so. Board has is initially responsible for coordinate development of generation, transmission and distribution of electricity in Meghalaya in most efficient, reliable and economic manner. In order to bring about accountability, transparency, competitive reduction of losses, improved performance for better customer satisfaction, the government has unbundled MSEB into 4 corporate the Meghalaya power scheme. I will show the scheme separately, my lord. Applicant has been created, my lord, under transfer scheme and core function of state government of distribution of electricity in the state of Meghalaya was assigned to the appellant. However, Meghalaya Energy Corporation is the holding company whose 100% shareholding is with the government of Meghalaya. Under the transfer scheme, applicant was assigned work to ensure the distribution of electricity to every household in the state. Applicant has been acting as an extended limb of Power Department of Meghalaya and is distribution company of the state of Meghalaya.
Okay.
The majority of the board of directors are government officials. 3 key officials applicant mentioned in website of web portal are Indian so and so, my lord. Now, kindly see next. The operational creditor has provided supply under the Saubhagya scheme. Therefore, it is bound to comply with the provisions of the scheme. Government of India has provided Saubhagya scheme, my lord, which I have already shown in detail, my lord. Now, 13. On 11th 10 OM was issued by Ministry of Power outlining objective of Saubhagya scheme. OM stated that the scheme has got sanction of President of India. Objective of scheme is to achieve universal household. OM further stated that distribution companies and state power departments are eligible for financial under in para 5 of OM state categorized the 2 groups, a special group, Meghalaya under special category and other special category group. For the para 85 para states that 85% budget of the scheme for the states like Meghalaya will come from Government of India, 5% will come from state government, rest will come in terms of loan. In terms of para 5 of Government of Meghalaya is required to fund 5% of the budget. In terms of para 5C, state union territories are under the obligation to ensure implementation of the scheme, completion of work of household electrification. In terms of para of Government of India is having prime responsibility to ensure effective ensure implementation of scheme in para 11 rural electrification corporation limited has been named as nodal agency for operationalization of scheme. In terms of para 12, district administration of the state will involve the implementation of any regular monitoring of scheme. In para 16 of OM, expenditure under the scheme will be debitable under Ministry of Power. Yes, yes. Now this is, my lord. Now guideline also, my lord, kindly see guidelines also. Let me place this guide.
These are your submission before
Over the NCLT. Why I am showing this in detail, my lord, how it has been dealt by the NCLT is also important. Now kindly see 401. Now 3 letters which I have to show your lordship, that why MEPDCL did not make the payment. That first letter your lordship will find 501. 501, 502 and 257. 3 letters are there, my lord.
501. Yes.
Closure of a project under Pure Sabhagya scheme. That is 19th August 2021 letter. In inviting a reference to this department's letter referred to above, whereby proposal for closure of Sabhagya scheme was submitted to REC Limited, I am directed to request you to kindly adhere to the following conditions. Balance grant to be received under the Sabhagya scheme shall not be paid to the contractor till the inquiry report of inquiry committee set up by the government under is received.
What happened here?
Here, the inquiry, because of allegations and against the working of this, inquiry committee was constituted, my lord. And therefore,
was the inquiry committee?
The inquiry I have placed, I have those details, my lord. I will place those details also, and it is part of my pleading also. I will show, my lord.
Then okay.
Then the purpose only on sovereign function, because I have to show that this was the direction of the government, whether in teeth of the direction of the government to a government company. Can it be said, my lord, I put a question to myself, that debt was due and payable to the contractor?
Yes.
Now second letter your lordship will find at 501, sorry 502. That is of 23 letter. I am to inform you that state government-wide notification number had instituted an independent inquiry committee regarding execution of all schemes and projects in last 10 years. An inquiry report was submitted by committee on 31st March 2022 to the state government, which is still under the examination. Power Department of Government Meghalaya instructed MEPDCL to adhere to the following conditions before releasing any further payment against Sabhagya scheme. Balance grant to be received under shall not be paid to contractor supplier till the report of independent inquiry committee received. Proper documentation and verification of work done and submit report along with the photograph. So then they said that you do this exercise also. The making depend law department government they have planned for any further disbursement towards any scheme and fund claims would require approval of cabinet. After thorough action taken, report is presented to the cabinet, corrective steps taken, while the recommendation of the independent inquiry committee headed by retired judges and retired IAS officers, senior technocrats, it is interpreted that all the time DISCOM boards examines, adopts corrective steps, cabinet approves the future course of action, payment may not be immediately possible as current Meghalaya is faced with election model code of conduct, etc. My lord, I'm only limited purpose of showing this thing, my lord, is that it is a sovereign. First, MEPDCL was extended limb for these 2 projects. It was discharging the sovereign function, and third, it was not at liberty to clear the to pay the dues debts. It did not become due payable.
Yes.
And 257, my lord. Get me 257. That is 4th, because I have shown your lordship 9th August 2021 letter, 10th February 23 letter, in between on 4th April 2022, my lord.
50?
That page is 257.
So next letter?
This was in between, my lord. This is 4th April 20. These are 3 letters, my lord. First is 19th August 21. Second is 4th April 22, which is at page 2.
Second is 10
That is 10th February 23, my lord. I inadvertently showed the last letter, my lord. There was in between one more letter, 4th April 2022 letter, my lord.
What does it say?
Yes, 3 letter. Of the Power Department.
Page number, please.
Page 257.
Page 257.
Yes, my lord. It also says, this letter also says no payment. If your lordship will say 257, state government is directing MAPDCL not to make payment. Now this was placed, the last two line, balance grant is DDGI, additional infrastructure, so and so. Till the inquiry is over, MAP shall carry out the final documentation verification work executed. So these 3 letters showed that there was a direction by the state government, my lord. That is 19th August 21, 10th February 4th April 22 and 10th August 10th February 23, 3 letters, my lord. Now kindly see 401 of my case before the NCLT. There was a charge by CAG 401, restrictions on applicant to freeze the payment to a contractor under Saubhagya scheme due to ongoing inquiry. Applicant is state instrumentality.
Yes.
State instrumentality and under obligation to ensure fairness in award of contract. Award of contract is under scanner because the contract was awarded by operational creditor to package A, which were higher than the estimated cost. Soon after that, operational were highlighted newspaper reports. These are CAG report. Then thereafter inquiry commission report on that is inquiry is also placed. Then those letters are referred, which I have shown independently to your lordship, and that 404.
Okay, anything else?
So this shows that these are the reasons for not making the payment. Pleadings we have said on pleading, my lord. Now coming to the Electricity Act, my lord, that Electricity Act, this transfer scheme has taken place. This transfer has taken place in terms of transfer scheme, my lord. So I first show your lordship the transfer scheme that your lordship will find. Give me transfer scheme. There is a transfer scheme, my lord, under which it has been transferred. I have already shown tripartite agreement, my lord, that your lordship has taken note. And under the transfer scheme, the assets have been transferred, and page your lordship will find of the transfer scheme that at page 415. This is also under the Act only, my lord. Kindly see 415.
Yes.
In exercise of powers conferred under section 131 and 133 and other applicable provisions of Electricity Act 2003, the state government hereby makes the following scheme for providing and giving effect to the transfer of assets, properties, right, liabilities, obligations, proceedings and personnel of Meghalaya State Electricity Board to, namely, these are the corporations, my lord, and then, my lord,
yes,
the assets of the state government which was vested in the board has been transferred to these companies which are 100% control companies of the government. And transferee is defined, my lord, in 416. Transferee is defined in 416, my lord. And kindly see assets. E-Milord. Assets means power system assets. So these are the assets of the state government. It is not the asset of the MEPDCL, and they would take over and they will sell it and so and section also, Your Lordship, kindly see the Electricity Act in the light of the transfer scheme. Electricity Act, that is provision 130, Article 131. My limited endeavor in this matter before Your Lordship is to show that everything which was done by MEPDCL was in discharge of sovereign function and sovereign function alone.
Yes.
And if it is a sovereign function, my lord, IBC code is definitely not applicable. And if it is not applicable, it is a case of wholly with. I have 3 judgments on that point also, my lord. Now, Section 131 of Electricity Act. With the effect from the date on which transfer scheme prepared by the state government is give effect to the objects and purpose of this act is published, or such for the date as may be stipulated by state government hereinafter. Hereinafter in this part, refer to effective date. Any property, interest in the property, rights, liabilities immediately before the effective date belong to State Electricity Board shall vest in state government on such terms as may be agreed by state government and the board. Any property, 2. Any property, interest in property, right or liability vested in state government and subs shall be revested by the state government in a government company or in a company or companies in accordance with transfer scheme so published, along with such other property, interest in property, rights, liability of the state as may be stipulated in such scheme, and as such terms and conditions may be agreed by the state government and such company and company being state transmission or generation or transmission as the case may be. Now the 132 also, my lord, what will happen in case of proceeds of sale of transfer board, because IRP will do what? It will sell the assets for sell the assets. The idea is to revive the company. IRP is not the IBC is not meant for clearing the debt, my lord. It is a purpose is to create, that is a separate limb of the argument, but I am right now on limited issue, my lord. In the event that board or any utility owned or controlled by appropriate government is sold or transferred in any manner to person who is not owned or controlled by appropriate government, proceed from such sale transfer be utilized in priority to all other dues the following order, my lord. So his dues will not be cleared if IRP is going to sell the assets, my lord. Dues of the officers, your lordship has seen 900 crore rupees is due to officers. Your lordship has been 900. Your lordship has given some schedule in which we are making the clear. Your lordship remember those? Yes, the huge dues. So their dues will get cleared, and we will be without electricity. Payment of debt and other liability or transfer as may be required by existing loan covenants. So the position of this MEPDCL is no different from NHAI, my lord.
Okay.
My position is no different from the NHAI. Now kindly see, my lord, how the commission has dealt with this aspect.
Yes, that's more important.
Yes, my lord, because
see, these points can't be taken on appeal.
Because the question is, my lord, question
I understand
that
why
it is a sovereign.
Why you try to invoke jurisdiction is because of the special circumstances, like you said.
No, one circumstances, and it is a sovereign function.
File, how much would you have to deposit?
No, my lord, we have to deposit 50%, and so because my case is
What is outstanding amount?
That is not an issue, my lord. The issue is, my lord, as on today, my lord, if it is a sovereign function, then the IBC code has no application. Then this court alone has. Otherwise, if your lordship feels that I have to go, your lordship will protect me, I can go. But my case is, my lord, that I am squarely covered. And how I am squarely covered, it is because NCLT has glossed over this entire issue. I don't know for what reasons, but kindly see how NCLT has dealt with this. First, Lordship, I have shown the submission of 4.2 at page 25. 2 at page 25 of the page 20 NCLT order, my lord. Paragraph 4.2 at page 25.
Yes.
Now section is quoted. Default means non-payment of debt when whole or any part of installment amount of debt has become due and payable. It will become due and payable only when the state government says that you make the payment and I don't make the payment, my lord.
Yes.
The 60 crore rupees is the principal amount, 30 crore rupees is interest. If he is ready to give up interest, I can take instruction and we can make the payment.
Yes.
Because 30 crore rupees interest he is asking for at the rate of 18%.
Okay, continue.
Yes, my lord. Now, corporate debtor has also, lordship, page 27.
Yes.
There is no default since the subject contract supply have been issued under the Saubhagya scheme. Under the provisions of this scheme, corporate debtor is merely a custodian of funds to be released by central government for the state government for effective implementation of this scheme. Unless the government of Meghalaya gives an approval, fund from REC cannot be utilized by operational creditor. Being a contractor under the Saubhagya scheme is bound to comply with terms and conditions. Corporate debtor is neither liable for any payment nor have control on the payment or process and is mere facilitator of the process. I am agent. My lord, MEPDCL is agent. This is an insolvency proceeding against the state government, which is not maintainable. That is why state government, they could not have, lord. And then kindly see 6.34 at page 36. Page 36, 6.34. Corporate debtor, a government entity created under the statute.
Yes.
Is a statutory entity constituted under the Meghalaya power sector and the scheme whose core function is distribution activity within the state of Meghalaya. Is MECL is holding company of corporate debtor, is 100% owned by government of Meghalaya. Thus, the corporate debtor is fully controlled by state government, acting instrumentality of electricity distribution sector. A measure of the directors of the board of directors are government officers, secretary, law, etc. Now 6.37 DOP GOM white letter dated 19 directed corporate debtor to withhold all the payment till the inquiry proceedings are conducted. It is submitted that corporate debtor, being an extended limb of the state, is duty bound to act.
Your submissions.
Yes, these are my submissions, my lord. And then, my lord, findings is page 39, paragraph 8.
Findings,
yes.
Yes.
It has been asked that corporate debtor is a government company engaged in electricity distribution across the state of Meghalaya and functions merely a custodian of government funds under this scheme. Under such Saubhagya scheme, according to corporate debtor, disbursement of fund is contingent upon release and verification. I am reading, sorry, 8.1. I am sorry, my lord. 8.1, 8 page 39, paragraph 8, 1. Corporate debtor, while not wholly disputing the underlying contractual transaction, has resisted the maintainability of the petition primarily on the ground is a government company. It has been asked that corporate debtor is a government company engaged in electricity distribution across the state of Meghalaya and functions merely a custodian of government funds under the scheme such as Saubhagya scheme. According to corporate debtor, disbursement of fund is contingent upon the release and verification of state government, and delay on non-payment of result in systemic policy linked constant rather than financial distress. It is argued that extended limb of the state, the corporate debtor should not be subjected to insolvency under the code. Now, then your lordship will see, they say that is it 8.4.
The finding on this.
Yes, which was read by my friend also. A conjoint reading makes it clear that government company is first and foremost Company Incorporated Companies Act, and is stated that a government company is merely subcategory based on ownership. It is juristic character, remains of a company under the law. There is no problem. There is no dispute on this finding.
Yes.
Section 3(7) of corporate person to include defined as Companies Act. Thus, government companies are not excluded from the purview of the code. I bow down. I am not excluded, my lord, but on the contrary, they are especially included in corporate. Legislative intent of the scheme is so and so. In the Honorable Supreme Court in Hindustan Construction drew a clear distinction between statutory government bodies and national highway and created by statute to perform sovereign function, and government companies incorporated under the Companies Act. I am incorporated under Section 131 of the Electricity Act. While the former being a statutory authority are immune from insolvency in proceedings, so if I am also under 131, my lord, I am also immune. And government remain amenable to court. Court observed from that part is quoted, my lord. I'll take your lordship to the judgment separately also. CRP can be initiated as a government company by virtue of being covered. First part, Code clear, NHPC, NTPC, IRCON being public sector undertakings are government companies incorporated under Companies Act. They would be governed under 3(7) of the Code. They are not under the Electricity Act, my lord. However, Supreme Court has laid down so far as NHI concern referred to object and reasons for national highway. I am also showing, I am going to show my objects also under the Electricity Act. Code cannot be used against statutory bill because no so and so. 8.8 is the crux of the finding, my lord. In the present case, corporate data is not a statutory authority constituted under the enactment or perform sovereign function but a public limited company. On what basis you come to this conclusion, my lord? That's the question I put to NCLT. Corporate data's previous conduct in making substantial payment of operational creditor without state approval demonstrate its functional autonomy inconsistent with plea. 3 letters I have shown. When there was no restriction, payment was made.
Yes.
So this is, so therefore, my lord, my submission is, and 8.9, in view of the discussion, we are unable to plead the corporate data stands outside the purview of the court. Corporate data being a state government company incorporated under within the reference of corporate person. I have shown everything, Electricity Act, the purpose.
It's only findings on the entire.
Yes, entire material, my lord.
That's 3-4 paragraphs.
Yes, 3-4 on this issue, my lord. There are other issues also which they are finding, but on this issue, this is the only, and one I should not be guilty of the communication also, my lord, because I better lose, but I have to place everything. 10.18, my lord. Sorry.
Yes.
Page, please.
Page 53.
But they have considered this also.
Is internal procedural requirement, my lord. Internal, my lord, as on today, your lordship, before your lordship, today is only limited issue whether the interim order should be confirmed or not, my lord.
Yes.
Because there is no reply to my writ petition, there is no reply to my amendment application.
It's taken to
yes, and so therefore, my lord, I have shown sufficient material to show, because I can take your lordship, because sovereign function, I am out. The commission is also not saying that if you are not, commission is also not discounting. Commission is saying no, you are a company created under the Companies Act, therefore you are covered. That is the sum and substance of finding of the, but commission has not gone into this aspect of the matter, my lord. When I have pleaded everything, I have shown everything. This if I would have been wound up, if there was no direction and I was not having money to pay it. I was having money, but there is a restriction to by the central government, state government, committee, inquiry, commission. And whether it will become debt due and payable under the act, that is one aspect of the matter. Second, it is a sovereign function, pure sovereign function, my lord, and commission is also saying sovereign function. You have autonomy. What autonomy? You have seen these letters and you are saying internal communication. Those letters can be set by internal communication. Sabhagya scheme, it's your own scheme. And how it is maintainable, my lord, I can show 3 judgments, recent judgment also on this aspect of the matter, my lord.
Now show the judgments.
Yes, my lord. Kindly give me the compact.
You have given them citations?
Yes, citations, and I have copies also, my lord. Just first judgment, let me just. Yes, just give me. Just give me. So, the first judgment, my lord, on the issue is, so because, my lord, there are sovereign functions issue and there is a alternative remedy issue, my lord. So first judgment, 2023 Justice Dipankar Dutta judgment. Yes. Godrej Sara Lee versus Excise and Taxation.
Citation, please.
Citation is 2023 SEC Online SC 95. Yes. Godrej Sarali. And then your lordship kindly see paragraph 4 first. Before answering the question, lordship have answering the questions, we feel the urge to say a few words on the exercise of writ powers conferred by Article 226 of the Constitution, having come across certain orders passed by the High Court holding writ petitions not maintainable merely because alternative remedy provided by relevant statute has been pursued by the parties, has not been pursued by parties desirous of invoking the writ jurisdiction. The power to issue prerogative writ under 226 is plenary in nature. Any limitation on the exercise of power, such power must be traceable in the Constitution itself. Profitable reference in this regard may be made to Article 329 and amendment of other similarly worded articles of the Constitution. Article 226 does not in terms impose any limitation or restraint on the exercise of power to issue writ, while it is true that exercise of writ powers despite availability of remedy under the very statute which has been invoked has given rise to action impugned in the writ petition ought not to be made in a routine manner. Yet the mere fact that petitioner before the High Court in a given case has not pursued the alternative remedy available in himself cannot mechanically be construed as ground of dismissal. It is axiomatic to say that the High Court, bearing in mind facts of each particular case, has a discretion whether to entertain a writ or not. One of the self-imposed restrictions on the exercise of power under 226 have evolved to judicial precedent is the High Court should normally not entertain writ petition where effective and efficacious alternative remedy. At the same time, it must be remembered that mere availability of alternative remedy of appeal or revision which party invoking the jurisdiction of the High Court under 226 has not pursued would not oust the jurisdiction of the High Court and render the writ petition not maintainable. In a long line of decisions, this court has made it clear that availability of alternative remedy does not operate as absolute bar to maintainability of writ petition, and the rule which requires a party to pursue the alternative remedy provided by statute is a rule of policy, convenience and discretion than a rule of law. Though elementary, it needs to be restated that entertainability and maintainability of writ petition are distinct concepts. The fine but real distinction between ought not to be lost sight of. The objection as to maintainability goes to the root of the matter, and if such objections were found to be of substance, the court would be rendered incapable of even receiving the list for adjudication. On the other hand, question of entertainability is entirely within the realm of discretion of the High Court. Writ remedy being discretionary, writ petition despite being maintainable may not be entertained by a High Court for many reasons, or relief could even be refused to the petitioner despite setting up a sound legal point if grant of claim relief would not be further public interest. Hence, dismissal of writ petition by High Court on the ground that petitioner has not availed alternative without, however, examining whether the exceptional case has been made out for the entertainment would not be proper. My lord, I say, my lord, it is an exceptional case. Because if IRP is appointed, he will sit on my MEPDCL. Distribution of supplies of electricity in the entire state of Meghalaya will get disturbed, including even in our High Court. It's not one of those ordinary cases where your lordship has relegated the parties to the alternative remedy. It is, your lordship has seen that maintainability and entertainability, these are two different concepts. Yes. It is a maintainable, whether it is to be entertained or not, it is the discretion lies with this honorable court only. In all cases, I keep coming before your lordship saying that writ is not entertainable or maintainable. Yeah. And in some cases, your lordship has entertained, and some cases your lordship has relegated the parties to alternative remedy. A little after dawn of Constitution, the Constitutional Bench of this court in decision reported in State of Uttar Pradesh versus Muhammad Noor had the occasion to observe the follows. In the next place, it must be borne in mind that there is no rule with regard to certiorari as there is with mandamus, that it will lie only when there is no equally effective remedy. It is well established that provided that requisite ground exists, certiorari will lie although a right of appeal has been conferred above the statute. Halsbury Law of England, volume so and so. The fact that the aggrieved party has another and adequate remedy may be taken into consideration by Superior Court in arriving at a conclusion as to whether it should, in exercise of its discretion, issue a writ of certiorari to quash the proceeding and decision of inferior courts subordinate to it, and ordinarily Superior Court will decline to interfere until the aggrieved party has exhausted his other statutory remedies, if any. But this rule requiring the exhaustion of statutory remedies before the writ will be granted is a writ will be granted is a rule of policy, convenience and discretion than a rule of law, and instances are numerous where party of writ of certiorari has been issued in spite of the fact that aggrieved party had other adequate legal remedy. 6. At the end of this last century, this court in paragraph 15 of its decision reported in 1998 8 SEC 1, Whirlpool Corporation with the Registrar of Trademark, carve out exception on the existence whereof a writ would be justified in entertaining a writ petition despite the party approaching it not having availed the alternative remedy, provided the statute same writs as under, where writ petition seeks enforcement of any of the fundamental right, where the violation of principle of natural justice, where the order are wholly without jurisdiction. My lord, if it is a case of wholly without jurisdiction, then I come under the Whirlpool also. Not too long ago, this court in decision reported in 2021 SEC Online SC, Assistant Commissioner of Sale Tax Commercial, has reiterated the same principle. That apart, we may also usefully refer to decision of reported in UP, State of UP versus Indian Hume Pipe, so and so. What appears on a plain reading of a former decision is whether a certain item fall with an entry in the sale tax statute raises a pure question of law in its, and if investigation into fact is unnecessary, High Court could entertain a writ petition in discretion, even though alternative remedy was not availed, and unless exercise of discretion is shown to be unreasonable or perverse, this court would not interfere. In the latter decision, this court found that issue raised in the appellant to be distinctly legal, requiring determination by the High Court without putting the appellant through the mill of statutory appeals in the hierarchy. What follows from this decision is where controversy is purely legal. One, it does not involve dispute question of fact but question of law, then it should be decided by the High Court instead of dismissing the writ petition on the ground of alternative. And I am raising the pure question of law, my lord. I am raising pure question of law that I am constituted under the Act, Electricity Act. I am discharging sovereign function. Electricity is part of Article 21, right to life, my lord, and there is no authority on this point. There is no authority examining all these on point. I have checked, my lord, under the Electricity Act and under the various act, that these points have been raised which are peculiar and unique to our state, my lord. So therefore, my lord, and then there are series of, this is 23, my lord, and then the other judgment is also there, Radhakrishna Industries, my lord, that is also by Justice Chanchur, and even Embassy judgment also, where the Honorable Supreme Court in IBC Code itself said that the IBC NCLT has no jurisdiction. That was in the context of, my lord, the grant of mining lease to the company which was under appointed under IRP. That judgment I will also place, but first, your lordship, kindly see the Radhakrishnan Industries, only one paragraph, my lord.
Citation, please.
Sorry, this 2021 6 SEC 771. Para 19, 24, 26. Now B1, your lordship will see para 19 is the submission, maintainability of writ petition before the High Court. My lordship may skip this part. They are all arguments which I have placed before, my lord, and then legal position which is there at page paragraph 21. and 24, my lord, maintainability of writ petition before the High Court. High Court has dealt with the maintainability of writ petition under Article 2 relying on the decision of CC versus Glaxo. High Court noted that although although it can entertain a writ petition at 226, it must not do so when aggrieved person has effective alternative remedy available in law. However, certain exceptions to this rule of alternate remedy include where statutory authority is not acting in accordance with the provisions of the law or acted in defiance of the fundamental principle of judicial procedure and has resorted to invoke provisions which are repealed, or where an order has been passed in violation of principle of natural justice. Applying this formula, High Court noted that appellant has alternative remedy available in GST Act and petition was not. In this background, it becomes necessary for this court to dwell into the rule of alternate remedy and rule of exposition. Whirlpool is cited, my lord, in paragraph 25, and Whirlpool then 26, Harbans Sahni versus Indian Oil Corporation in paragraph 26, my lord, and then, my lord's principles are summarized in paragraph 27. The 27.1, my lord. The power under Article 226 of the Constitution to issue a writ can be exercised not only for enforcement of fundamental rights, but for any other purpose as well. Some disturbance. Mr. Goswami, your mic is not mute.
Yes.
The High Court has discretion not to entertain writ petition. One of the restrictions placed on the power of the High Court is whether an effective alternate is aggrieved person. Exception to the rule of alternative is where writ petition has been filed for enforcement of fundamental right. Under Part 3, there has been violation of principle of natural justice, other order proceedings are wholly without jurisdiction, or the virus of legislation and the change. 27.4, alternate remedy itself does not divest the High Court of power under 226. In appropriate cases, ordinarily a writ should not be entertained when efficacious is provided in law. When a right is created by statute itself, which itself prescribes the remedy or procedure for enforcing right or liability, resort must be had to particular statutory remedy before invoking under so and so. This rule of exhaustion is a rule of policy, convenience and discretion. Justice Dipankar Datta has also elaborately dealt with that. 27.6, in cases where there are disputed question fact, High Court may decide decline to jurisdiction or writ. However, if the High Court is objectively of the view that the nature of country requires exercise of jurisdiction, such a view not really be readily be interfered with. So, Milord,
Only read 27.5 also. Please read 27.5 also.
I've read it. Again, I will read. When a right is created by statute, I'll read that also. When a right is created by which self-prescribed remedy or procedure for enforcing the right of or liability.
I've seen that.
I've read, Mr. Goswami, your mic probably was.
I've marked it.
We marked it also. Everybody has read it. My friend has also read it.
The rule of exhaustion, statutory remedies, the rule of policy, convenience and discretion.
Yes.
So that
has been. Now the judgment which.
Yes. Next judgment.
The two judgments I have said. Now coming back to, my lord, this judgment of
Embassy.
That judgment is embassy is citation. Give me the citation. Hindustan, then embassy is what is the citation? Give me the embassy. I'm missing the embassy. Sorry. Embassy was cited before your lordship. Just embassy
2020 13 SCC 308.
You have got copies? Yes.
Yes.
Now kindly see the facts of the case, my lord. I have virtually argued the law in entirety without even. Now, lordship will see the provision in paragraph 11. Paragraph 10. In the background of facts narrated in the light of the royal contention above, first question that arises for consideration is as to whether High Court ought to interfere under Article 226 220 Constitution with an order passed by NCLT in procedure under IBC Code, despite availability of statutory remedy of appeal to NCLT. It is beyond any pale of doubt that IBC is a complete code itself, as observed in the innovative so and so, is a rule of exhaustive code on the subject in so and so. It is also true that IBC 2000 is a single unified covering the entire gamut of law, mechanism, etc., my lord, there is a procedure, everything is laid down. Then your lordship will kindly see the discussion on the alternative remedy, which starts from paragraph 24. Because High Court in this case exercised the jurisdiction under Article 226. Therefore, insofar as question of exercise of power conferred by Article 226, despite the availability of statutory alternative remedy, is concerned, any SMINIC cannot be relied upon. Distinction between the lack of jurisdiction and wrongful exercise jurisdiction should certainly be taken into account by High Court when Article 226 is sought to be invoked by passing statutory special. On the basis of principle, let us know whether the case of State of Karnataka under the lack of jurisdiction on the part of NCLT or statutory rules or a wrongful exercise of jurisdiction. So, for instance, asking a wrongful question, asking a wrong question, or applying a wrong test, or granting wrong relief. All three are met in my case. Question is wrong, relief is wrong, and applying the test is also wrong. MMDR Act is, and then finding is 46 million. Therefore, in fine, our answer to the first question would be NCLT did not have jurisdiction to entertain an application against the government of Karnataka for direction to execute supplement lease deed for execution of mining lease. Since LC chose to exercise it does not vest in need law, High Court of Karnataka was justified in entertaining writ petition on the basis of NCLT was quorum non juris. Here it is in effect the exercise of jurisdiction against the state government, my lord. So in all three judgments, my lord, alternative remedy, what my friend is pleading before your lordship, that there is an alternative remedy. Your lordship has seen that this is one of the exceptional cases where your lordship has the right to entertain the petition. The petition is maintainable. So far as entertainability is concerned, my lord, consequences, if it is not, they will be catastrophic. The IRP will sit over. The MEPDCL will be taken by interim resolution professional. His job is to, because those are on merit, I have not gone into merit aspect, there are number of arguments on merit, my lord. His job is on the merit, his job is on the issue of how to revive the Sikh industry. Here it's not a case of Sikh industry, my lord. And when I place all these materials, the tribunal says you have functional autonomy because you made some payment. And all those correspondences were of the government or direction by the government. Being a government company, I am bound by those directions, my lord. We are set aside saying that it is your internal mechanism. And 18% interest on 60 and odd crore, 90 crore rupees was held to be debt due and payable under the law, my lord. And kindly see now, Hindustan I have cited, my lord, one, and my lord, I have 10 minutes more, my lord, so I will finish the Hindustan also, my lord. Because it is a marathon day for me.
Because Swami, you want to make any replies?
One.
Yes, Lordship.
You want to make any replies to the arguments? Do you want to make any replies to the arguments? He's concluding it in 10 minutes.
Look,
yes. The court sits beyond 4. I don't know the court time.
No, because then you'll have to make it tomorrow, your replies. I don't want to hold on to this matter. But tomorrow you make your replies.
As far as Lordship convenes.
No, tomorrow, sir, we can,
I need to reply to certain issues.
Right.
No, if the AG concludes, then I can continue and then continue tomorrow.
No,
I will not take much time.
The thing is that let him conclude it by 4 o'clock because we have other engagement. Then you reply tomorrow, half an hour. Yes.
Now, your lordship kindly. Now, Hindustan construction, my lord.
Yes.
Now, before I take your lordship to Hindustan construction, one document which I wanted to show, then I will take your lordship to Hindustan construction. Because the conduct of the party, my lord, is also a factor which your lordship may consider. Yeah. Give me the paper.
Yes. Yes, Hindustan.
Yes, my lord, page 568, my lord. No, sorry, Hindustan I'll show later on, my lord. First I will show one page, the one document, my lord. From paper book, that amendment application, my lord. Because my friend has not submitted any reply on merit, my lord, so far as merit is concerned. He has time, my lord. Now kindly see, this is a complaint which is lodged to the Prime Minister office by Himanshu Jain of Satnam Global, my lord.
Who is Himanshu Jain?
He is the director of Satnam.
But after the matter has been
matter has been filed, my lord. That is what yes, 30th September, your lordship will see 568.
Isn't Hindi?
You know, Hindi, English both are running together, my lord, separately.
Without the AG, I'm just telling Lordship, as an officer of the court, I do not approve this action of my client. I mean, very candid.
Yeah.
Yes.
No, it's very unhealthy, Mr.
Yes.
Swami.
When the matter was sub judice, it was not supposed to be done.
Now, my lord, if your lordship will kindly see the allegations which have been levelled.
Yes. Yes.
Page 574, English Standard.
Yes.
After that, my only hope for justice was the court. I filed a petition in NCLT Guwahati bench, and approximately after 13 months, the Honorable Court ordered an MEPDCL to make the payment immediately. There is no direction. However, before NCLT decision was reached, MEPDCL obtained a stay from the Honorable High Court of Meghalaya based on false facts and was verbally told that this government is ordered and told that this is the government's order to keep the matter pending for 1 year.
Who has said? You have said it to him.
Verbally told. Verbally,
you told the parties.
No, I did what he
said. What is attributed to you?
No. That is what I was also wondering. If a lordship will say, obtain a stay from the Honorable High Court of Meghalaya based on false facts and was verbally told. He was verbally told by whom? By whom I don't know, my lord, that this is the government's order to keep the matter pending for 1 year. This is not only abuse of the court's process, but by my company, which is worked so and so. This is the state of affair, my lord. That I have shown, my lord, in NCLT. I have shown in my NCLT all those correspondence have.
I even asked for fine GST returns to be waived before a PMO.
Yes, my lord. No, what I am saying, my lord, when the matter is pending and we have no, lordship has seen, my lord, in none of the matters.
No, but allegations of corrupt conduct are here also, conspiracy.
Yes, my lord, this is in none of the matters, my lord. I want to delay by even single day.
This is anyway.
And
take a note of it. Yes,
yes,
come to HCC.
Yes, my lord.
Yes, this is very unhealthy. Will not say anything, but
yes, my lord.
Yes.
Now, in Hindustan, my lord,
yes,
the relevant paragraph. I'm sorry, my lord. I have to.
You placed that. You already placed it.
Yes, I have placed. My friend has tried. Yes, my lord. My friend has said that it is not correctly placed. Yes, correctly, not correctly placed, my lord. Yes, my lord. I have placed it. Kindly see the paragraph 11, my lord.
It's here only. 1 second.
Yes, it should be there in your lordship.
Marked it. That's
yes, my lord. Flaming B, flaming B. I'm flaming. Our local.
He plays para 224.
Yes, my lord.
Yes. Anyway.
Yes, my lord. Now, yes, my lord. So far as the challenge to IBC is concerned, paragraph 11 exhorted us to read corporate person as defined in 37. Sorry, my lord.
Yes.
So far as challenge to IBC is concerned, Singhvi exhorted us to read the corporate person as defined under section 37 of Insolvency Code to include government bodies other than government companies. That was based on argument that the object sought to be achieved by it makes no difference whether the person sued is a corporate person, is a government company or body incorporated under the statute. He exhorted us to delete the words limited liability contained in 37 of the code, even 323G of the code, 37 of the stress upon positive aspect of Article 14 of the Constitution which permits such interpretation. Now, after his argument, my lord, of Justice, now paragraph 24, my lord.
24, yes.
Yes. NHI is concerned, Ms. Smith referred to statement of object reasons for National Highway Authority of India and some sections of the said act to show that NHI is statutory body which functions as an extended limb of the central government and which is which carry on sovereign functions of the laying down national highway. My lord, electricity is more precious than the highways, my lord. Obviously, IBC cannot be used. It's not a case of private discom here, my lord. Against such a statute, because no relation professional or private individual can take over the management of such body, my lord. What is the I principle? Principle is that and perform sovereign functions, nor can such body be driven by insolvency court. He referred to definition in 37326 so and so. And then, my lord, I put a question whether IRP will run MEPDCL.
Then para 70?
Yes, my lord. And you will also will see the other companies, my lord, para embassy, I have to go. Para 70, yes. From reading of the aforesaid definition, Mr. is clearly right in stating the three entities who owe money under arbitral awards to petitioner number 1.
Yes, would be subsumed.
Will be subsumed. Is it a case of owing some money under arbitral award, my lord? Within the part definition, however, as per NSI concerned, distinguishing the argument is early decision so and so cannot be accepted because that everything will be included. So where did I mislead, my lord? This law, this judgment is in my favor. And I have correctly interpreted the law, my lord. I have correctly, and electricity lordships will see 2 orders of this honorable court in Fleming, where the lordship has held that electricity, even because we took the plea that now MEPDCL state has no responsibility, etc. Then your lordship in Fleming B, you have Fleming B. My lord, there are 2 orders passed by. I'll place those 2 orders. I don't have copies, my lord. Fleming B, where prisoner complaint of rampant power cuts is a PIL 3 of 23 of the Meghalaya High Court only, my lord. And order dated 5/5/23. 2 orders have been passed, my lord.
PIL 3.
IPIL 3 of 23. Order dated 5/5/23, my lord. And order dated 14th June 23, my lord.
In the same matter.
Same matter, my lord. The petitioner complained of rampant power cuts in state and arbitrary load shedding are ironically even
5/5/23 and 14.
5/5/2023 and my lord 14 June 23. The PIL is PIL number 3 of 23.
Yes.
Ironically, even the order is being dictated. The power supply to this court has been interrupted. The power has resulted within a few seconds, but may sign that state ought to be adequate answer. Paragraph 4. Electricity is no longer a luxury. State's responsibility to ensure there is adequate availability of electricity as per demand, and plans should be placed to increase the future demands. Indeed, it is open to state to buy power from the open grid, inter-management, several whom operate in northeast, ensure adequate electricity available to citizen and subject to cost here before the citizen. So these 2 orders I will place, my lord, and then it was again repeated the same principle in the other PIL. The point which I am trying to make, my lord, that this is a sovereign function, not one of the run-of-the-mills cases, my lord, in which payment has been denied. And this court has the jurisdiction to entertain entertain and maintain both, my lord, the remedy. And the fact of the matter is that, my lord, if interim relief is denied, my writ will become infructuous. because that IRP will come, get appointed. My all accounts will be frozen. Salaries will not be disbursed because the board of directors will have no power under once IRP is notified, my lord. This is one of the extreme exceptional cases in which the state has, the MEPDCL has to move before your lordship, and on good grounds. It's not that there is no ground, my lord. I have shown that it is not a debt due and a debt which is due and payable under arbitration award. It is a debt, alleged debt, which is not due and payable. It will become due under the Saubhagya scheme. Your own case is that it is under Saubhagya scheme. So therefore, at this stage, if I am going to get none suited on this application, my lord, I will be rendered remediless, my lord, and state and people will suffer. That is all I have to submit, my lord.
Then you make a small note.
Yes, I'll do that.
And you reply tomorrow, Mr. Goswami, at 2?
Yes, at 2 tomorrow, Lordship?
Yes. We'll have some clear time. Tomorrow morning will be a bit different.
Yes, please.
Yes. Further hearing tomorrow at 2.
Oblige.